Good morning. Good morning. It's Thursday. It's August 22nd, and it's the unofficial first day of fall. Yes, some of you are going to be like, Emily, what do you mean? It's not the unofficial first day of fall. It is. It's a Starbucks fall menu day. So that makes it the unofficial first day of fall for basics like myself. I'm very excited about the pumpkin spice of it all, but we've got to be excited about something. Today, we have lots to talk about. We are talking about all of Donna Adelson's motions. I will do a road so far, don't worry. But Donna Adelson wants a smaller courtroom and wants her case dismissed. And she wasn't at Miami International Airport because she was fleeing the country to a country that didn't have extradition. No, you've all got it wrong. She was just traveling. Or at least that's what her lawyers say. We've got some updates on the Tom Girardi trial, and that's about all we've got for the day because I am still recovering and there's only so much one can do. So that's what we are up to today. Donna Adelson's getting ready to go to trial in September. So it's going to be here before we know it. And next week, I have lots and lots for you. Next week, we've got the preliminary hearing for Corey Richins, and then there's a motion in the Kohberger case, that big change of venue motion. I'm going to do a breakdown of the Kohberger motion next week. Well, all of the Kohberger motions next week before that hearing next Thursday. So I've got you covered. Today we're talking Adelson before this goes to trial. So I'm gonna, if I'm still taking deep breaths, it's just because we're doing the things. For all of you that are like, you sound so much better, thank you. I went to the doctor immediately and started taking medication. So I knew I was sick. This is what I've done better as I've gotten older. I could feel it coming and I went, I am getting sick. And then like 3 hours later, I'm like, oh, yep, definitely getting sick. And then the next day I went and got tested. I was like, I either have this or this. So I need to figure out what direction we go in. And then immediately started taking medication because I was like, I can't do this for weeks and weeks and weeks and feel much better, especially with the congestion. I'm just exhausted, but that's going to happen. I am clearing up in the face. And when I can breathe better, I can sleep better. And when I can sleep better, I can get better. And I've got pumpkin spice. So, all the things. We're doing all the things. So let's get into it. You guys, we have tons to talk about today. We've got, how many motions have I got on the docket for you? 1, 2, 3, 4, 5. Emily, that sounds optimistic. Yeah, that's real optimistic. It's real optimistic, but we're going to do it anyway. So with that, I'm going to roll the intro. You guys, we're going to get started with some quick updates. I've got an update for the Hannah Gutierrez Reed case. I've got an update for Girardi, and then we'll get into the Adelson of it all. Sound good? Hopefully that sounds good. Let's get rolling, guys. Oh, I almost ran the outro. Cheers.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Oh, law nerds, we have so much to talk about today. First, we're going to talk about Hannah Gutierrez Reed because I know you all are waiting for an update. No, Jason Bowles has not filed a response to the snark. Am I waiting for the snark response? Yes. I'm waiting for him to absolutely show up and just be like, this is an inappropriate level of snark for this prosecutor who the court has excoriated in their ruling in the Alec Baldwin case. Has that happened as of last night? No. But what did happen? Well, the court set a hearing date. So we get a hearing on the snark. Well, the hearing's not on the snark per se, but I imagine it'll come up because the prosecutor's motions were so snark-laden. So Friday, September 27th, we will have a hearing on the Hannah Gutierrez Reed motion for immediate release and the motion for new trial or dismissal due to discovery violations. So both of those are going to be heard on September 27th. That gives adequate time for the defense to respond. I will cover the responses when we get them from Jason Bowles, and we'll cover the hearing. If we're not in trial, we might be in trial. If we are in trial, then I will cover it when we have a gap in trial, but I will make sure that we have that for you in one way or the other, because I am waiting to see Judge Summer's face on this Google Meet. I am waiting for Judge Summer to just be like, so you thought that was a good idea, did you? I am waiting to see it all. But that's all the updates we've got in that case. There's a hearing date, end of September. We are working on putting a calendar in the app so that we have those court days there for y'all, so you can like plan around the docket. But that's on the docket for the end of September. But remember, Donna Adelson goes to trial September 17th, and that's jury selection. At the last hearing, and I'm not even going to go through the last hearing, I watched it. It's like, I don't know, maybe 5 minutes long. It wasn't a super long hearing. It was all just setting dates and talking about discovery. It was very much the nuts and bolts of court, but the court did do something unusual and bumped the court date forward. We'll talk about that when we get to this motion, all the motions in limine. The court did bump the trial forward about a week so that they would get out of those early Jewish holidays in October, and they wouldn't miss as many days of court to allow the defendant to observe those holidays, though in custody. But they bumped it forward, unusual to do. So it looks like jury selection, they're expecting maybe 5 days, a full week of jury selection starting September 17th. So we won't really start trial until the next week. So that trial might bump up against that hearing, but don't worry. We'll figure it out. I'll figure out between now and then how to clone myself and be 2 places at once. It's a very helpful thing. It would be great. I need like 3 of me on a good day anyway. God, my Animal Crossing island would definitely get to 5 stars if I had 3 of me. Griffin and I are in a race to see who can get that 5-star island first. And when I was traveling, Griffin was just like, I get to play Animal Crossing, blah, 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 when you're working. And I'm like, well, I get to be on a plane uninterrupted while you're at school. And he's like, that doesn't seem fair. I'm like, totally fair. It's totally fair. It's totally fair. So we are racing to get to our 5-star island, and we'll see who gets it first. I think probably Griffin, but I'm trying. It's brought a nice little fun competitiveness into our Animal Crossing-ness, and I enjoy that we're both like just focused intently on building very different islands, but trying to get to that 5-star rating. So what was I saying? Oh, I got to travel uninterrupted and play Animal Crossing, and my island would be better if there were 3 of me. Either way, we'll get that hearing for you, even if it is just that we have it on our second channel so you can watch the hearing without commentary first and then with commentary later. We'll figure it out. We're trying to figure out how to be in trial and cover other things. When I do gavel to gavel, that can be really tricky just because there's only so many hours in a day. But we're going to figure it out. So next week, I already talked about this a little bit. Next week, we've got 3 days of Corey Richens hearing, and then at least a day of Kohberger hearing. So we've got a lot of live court next week, which is fantastic. That's going to be all of next week. And then we're going to go, that's probably all of next week. And then the podcast will break down the motions before the Kohberger hearing next week. So that's going to get us through all of next week. So this week, we need to finish up talking about Girardi. It's odd because I saw some rumblings that Girardi might testify, but it seems like the state is in their rebuttal case unless they called somebody out of order, which is possible because I don't think Girardi's going to testify, but we'll see if he does. There's some rumblings. I think they're going to close probably today, but we will see what happens today in court in the Girardi case. And they should actually be getting back to court pretty soon. So after I do these summaries, maybe I will check in over on the former Bird app and take a look and see if we can, if we see what if anything people were doing. But we're going to take a look at the reporting from Law 360 and take a look at what the jury has heard in the Girardi case. And then we're going to get to Donna Adelson. All right, let us do that. Emily, are you sharing your screen? No. But I should be. You know, we're professionals here. It just is what it is. We did have a really good meeting with the engineers over at StreamYard. So we hope that when we do court next week, we won't have any of that really annoying clicking. So we're optimistic that has been fixed. So we'll see what happens. Let's talk about Chris Kaman, the CFO that was stealing from Girardi or has been accused of stealing from Girardi. Let's talk about him for a minute, shall we? Because that's what's been going on at trial. Briefly, part of Tom Girardi's defense is everybody else was stealing from me. I wasn't the one defrauding my clients. It's not me, it's them. Empty chair defense, right? Some other dude did it. Like the person who should be sitting here is the CFO. Like that's the person who did the shit. Blame them. They're not sitting here. That is a typical empty chair defense. Point at the person who's not in the courtroom. This is why prosecutors like to bring co-defendants into court together, because then they point the finger at each other and the jury's like, y'all are in it together. But in this case, the defendants were separated out. Girardi's going to trial first. The CFO is going to trial later. Remember, he had the side fraud, as the government called it. They're like, yeah, his cute little side fraud. Like he's the CFO helping Girardi steal from clients, and then he's stealing from Girardi. Because what's Girardi going to do? What's he going to do? Turn in his CFO who's cooking his books? Like once you're in it, you're kind of in it. So Girardi's defense is other dude did it. Blame him. But he was an old man. He didn't know what he was doing. He was just forgetful and everyone took advantage of him. Hopefully by my tone, you can see how I feel about that. I have very strong feelings about the Girardi case. I have been covering this since 2020. Very strong feelings about the Girardi case. So let's see what evidence the feds brought in with the, well, not the feds, the defense brought in with regard to the ex-CFO, right? Because the feds are going to be prosecuting this ex-CFO soon. And we learned about this when he got arrested in Baltimore, maybe? He got arrested on the East Coast coming back from the Bahamas for like a minute. The former fiance of ex-Girardi case executive Chris Kaman, Grand Cayman. No, he went to the Bahamas. Chris Kaman told a California federal jury in Tom Girardi's criminal trial Tuesday about a dramatic call she received from the former CFO, during which he told her he was about to be pinned for the firm's crimes and wanted her to flee to the Bahamas with him. They had already been broken up, right? They had been broken up. She had been on an allowance of like $20,000 a month with this dude. They had been broken up. And he calls her up and is like, flee with me to the Bahamas. She's like, yeah, no. The former CFO of Girardi Keese is a co-defendant in the government's wire fraud case against Girardi, but will be tried separately. Girardi's attorneys at this trial have pointed the finger at the CFO being responsible for the missing money from the firm's client trust accounts. Right. Empty chair. Girardi is charged with 4 counts of wire fraud and allegations he misappropriated $15 million from several clients. That number keeps shifting because the government has said up to $50 million. But in this case, they're not going to prove up to $50 million, et cetera, et cetera. So in the bankruptcy, it's over $100 million in liabilities he has. It's just all at this point. So Nicole Rokita, Kamon's ex-fiance, testified via video link and was called as a defense witness. She said the two were engaged for about a year and a half to 2 years, 2017, 2018, during which he showered her with expensive gifts, luxury vacations, and a $20,000 per month allowance. Is that even an allowance? That's a salary. That's like a really, really healthy salary. My finance people in the chat, what is that annually? Like if you're pulling in 20,000 take home, I mean, of course, taxes aren't coming out of this, assuming that, I mean, it's not on the up and up because he's stealing a fuck ton of money. But when you're taking home 20,000 a month after taxes, like how much money are you actually making? I don't know. Lots. Like lots. But this is the girlfriend allowance. Thank you, chat. You guys are like $240K a year. That should be easy numbers. 1220 lawyer math. I don't know. But all of you, thanks, chat. So like, yeah, $240,000 a year for dating somebody. I don't know. An allowance is such an odd concept to me if you're not like my child unloading the dishwasher. But anyway, she's like, it's our money. She said in 2022, so they broke up in 2018. In 2022, Bro calls her up and said, or she testified, quote, he basically told me he was going to flee the country because he was afraid he was going to be pinned for Girardi keys. Right. He got a target letter from the feds. He knew it was coming. Kimon wanted her to come to the Bahamas with him where he planned to start a new life. Down the street from Sam Bankman-Fried, apparently. The Bahamas, by the way, we talked about this in the SBF case. The Bahamas, by the way, will grant you residency if you spend a certain amount of money immediately. So they will, if you buy enough property or spend enough money in the country, they will allow you to kind of become a resident of the Bahamas. The Bahamas is like, sure, well, I mean, if you want to bring your money here, we'll take it. A lot of cruise ships, Bahamas have different employment laws. Emily, why are we going on a tangent about the employment laws in the Bahamas? Fun story I would love to tell you. I was a research attorney for civil judges before I became a district attorney. One of the most interesting cases I worked on was an employment law dispute from an employee that worked on a cruise ship. And trying to figure out which law applied was actually way difficult because the employee had gotten hired at like an expo situation in California, but then they had been terminated and disembarked in Florida. But the ship was flagged in the Bahamas and registered in the Bahamas. So it's like, whose employment law applies to the employment relationship on a cruise ship? Anyway, cruise ships are often governed by the law where they are flagged. Most cruise ships are flagged out of the Bahamas. Why? The Bahamas have some very employer-friendly employment laws. So cruise ships love being flagged under the Bahamas. I have no idea how much taxes the Bahamas take in from those companies. Hopefully it's a lot and it's worth it because a lot of cruise ships flagged in the Bahamas. That was a wild law tangent that I don't know if anyone needed to know about, but my inner nerd was like, this is a fascinating question. What law does apply? Either way, the Bahamas, it's always the Bahamas, not shocked. Like between the Bahamas and the Grand Caymans, the bank accounts, the cruise ships, the houses, the SBF of it all. Oh, the SBF of it all. So let's see. Emily, where were you? Oh, he was fleeing to the Bahamas. He wanted his ex-fiancée to come with him to the Bahamas to start his new life, right down the road from Sam Bankman-Fried. I said to him, do you really think that's a good idea? He's like, of course it's a good idea. The Bahamas sound better than jail. He thought it was a good idea until it came back and got popped. She said to him, do you really think that's a good idea? And he said the government would likely be able to trace any money from Girardi keys to him and then to her. They did. And when the feds showed up, this is how I pictured this going. This is complete speculation. This is how I picture, this is educated speculation based on everything we've seen in the filings. This is how this went. The feds were like, excuse me, we'd love to talk to you about your ex-fiancé. And she's like, I will tell you absolutely everything you would like to know. Let me tell you everything. Sure, love to tell you. She was just like, come on in, have a seat, love to tell you. Let me tell you everything about this man. I knew nothing, but I can tell you everything he did, and I can tell you about this weird phone call I got. So immediately she was like, immediately no. Immediately no. I am not, good for you. I'm not going down for this man. Good for you. She's like, I will tell you everything he said. Yep. So she said, do you really think that's a good idea? And he's like, they're going to trace all this money back to me. Right, they are. It says aside from being charged alongside Girardi on allegations of misappropriating millions of client funds from Girardi Keys, he's also charged in a second case with stealing millions from the firm in his own side fraud. The side piece of fraud, the fact that the government has just titled this the side fraud is hilarious to me. It's like he's helping Girardi steal, and then he's also stealing from Girardi. He was arrested in November 2022. He fled to the Bahamas in September that year, but was detained by federal agents 2 months later in Baltimore. Hey, I remembered that right. Wow. 2 months later in Baltimore's International Airport after he stepped off a plane from the island nation. Aside from luxury gifts and a $200,000 per month allowance, Rokita said that he also bought and renovated a home for her in Encino. And also, was she also going to be on Real Housewives? Because I think the Real Housewives of Beverly Hills all live in Encino at this point. Was she also going to be on Real Housewives? Is that what we were doing? It's like, oh, the housewives live in Encino. We'll just put her in Encino too. No shade to Encino. It gets hot out there, but no shade to Encino. Anyway, bought and renovated a home for them in Encino. This is part of the money that he was stealing that we've seen in the bankruptcy. Also started building a restaurant for her to operate, though it never opened. She said they broke up in October 2018, the same time she discovered financial documents that suggested most of Cayman's money came directly from Girardi Keys. How? How did you discover that? Oh, wait. She saw some of the checks, I think is what Kiki was saying. Kiki from the Talk of Shame podcast was in court talking about this testimony. And I'm pretty sure it's because she saw some of the checks. It goes on to say, I think everything was paid for by Girardi Keys, she said about her home renovation. She was 24 at the time that she started dating Kimon. He was 44. She believed at first his money was legitimately earned from Girardi Keys. He told her that he was a partner, though he does not have a law license, but she said she didn't exactly know what partner meant. He paid for a Las Vegas vacation, luxury purchases for them with his American Express card from the firm. And what we know from the bankruptcy, everyone at this firm had an Amex. Everyone had an Amex. And she also paid for a hotel stay and a vacation in Arizona with the card. Under questions from Girardi's public defender, she said that she never asked him where the money came from. Well, I mean, if the check's clear, are you going to ask? She was still testifying when proceedings ended for the day Tuesday, was expected to continue testifying Wednesday. 2 of Girardi's former assistants also testified Tuesday and said that they observed him slipping mentally in 2019 and 2020, but insisted he was still in charge of the firm until it closed in December 2020. We're going to talk about the testimony with regard to Tom Girardi's dementia in just a moment, because we need to take a second to thank our sponsor. Yes, we have a stream sponsor. You guys have seen this sponsor before. Foreo has been a great partner on the channel and has helped me take care of my skin even when I am traveling, even when I am sick. So if you guys have been interested before, maybe today is the deal for you, because there is a deal for the first purchasers. So take a look, and thank you to our sponsor, Foreo. A huge thank you to today's sponsor, Foreo. You guys know that I keep my makeup routine simple, and the key to that is good skincare, and Foreo is an essential part of my skincare routine and my self-care routine. The UFO 3 is a deep facial hydration device that uses a combination of warming thermotherapy, cooling cryotherapy, LED therapy, and T-sonic massage. So not only does it feel great, but you get that light therapy and you can feel the warming and cooling to activate the different masks that you're using. And the treatments are different based on the mask that you're targeting, and they target different skincare needs. And the routines on your app are like 90 seconds long, and you can use it without the app. But I love the app talking me through which zones of my face to target. I use it a lot when streaming long days in the morning because those T-sonic pulsation help me get fluid out of my face and flush it a little bit so I don't feel as congested and I don't feel as poofy, and I absolutely love that. So if you're ready to get the UFO 3 for yourself, it is rarely on sale, but of course, I've got a deal for you today. Get 30% off using our special link down below, and the first 50 Law Nerds to buy get an additional 10% off using code Emily. So Law Nerd, go get your discount, hit that link below and use code Emily, and let's get back to today's stream. Thank you again, Foreo, for working with me and being a great partner. And yes, I really do take the Foreo devices with me when I travel because I now need them. You know, when we reach a certain age, we need all of the things, but I also don't have the patience to do like hours of self-care. So it's really nice to do something quick and easy, and I absolutely love it. So once we talked about all of the Foreo UFO 3 goodness, we're going to talk about whether or not Tom Girardi is faking his dementia. If you follow Bravo, where are my Bravo fans in the audience? If you've been following Bravo, then you know that this has been widely speculated about since he went into a conservatorship. Right as the bankruptcy was breaking, it's like, and all of the sudden, he needs a conservatorship with his brother. And it seems that it's the same brother that was on payroll at the firm, though wasn't a member of the firm. And all of a sudden now it's a problem. It's just like, what is happening? And then we started hearing from Erica that there was this accident in 2017, and that's when things started to change. And it's like, what are we even talking about? So everything was fine until the law started knocking again. And then it was, oh no. Remember, Tom has been found competent to stand trial, meaning that that doesn't mean that he doesn't have any mental decline. It doesn't mean that in his 80s, things haven't changed. It means that he is competent to stand trial. So there is a fight going on about whether or not he had the capacity or the intent to defraud. Was he slipping or was he frauding is really what that argument is coming down to. And remember, the thefts in this case are going back to 2010. And some of the doctors are saying, look, he was carrying out complex frauds and spinning a web of lies to multiple different clients. This is not someone who's forgetting. This is someone who is lying and tracking what they're lying about. So let's take, nope, that's not what we wanted to do. Emily, what are we doing? So Girardi faked dementia symptoms, neurologist testifies. Tom Girardi had his neurologist testify. This is the government's rebuttal witness to rebut what Tom Girardi's doctor testified about. A neurologist from Vanderbilt, local, testified Wednesday in Tom Girardi's criminal fraud trial in California federal court that the disbarred attorney was likely exaggerating his cognitive problems in late 2020, just as his law firm imploded into bankruptcy. That all happened like right at the same time. And his legal problems mounted because he believed it would be beneficial. Look, lots and lots have wondered about whether that this was Tom going, I'm at the right age. This'll do. This will work. Who's going to question me? Who would ever question that I was faking it? Dr. Ryan Darby was called by federal prosecutors as a rebuttal witness to counter testimony from USC neurologists who testified in Girardi's defense that she diagnosed Girardi with mild to moderate dementia in early 2021. Darby said he came to a different conclusion and determined that in 2019 and 2020, Girardi was suffering from not dementia, but mild cognitive impairment, which is a less severe diagnosis that would have allowed him to continue to function in his job and be fully capable of committing the type of fraud the government alleges. Remember, Girardi or individuals from Girardi's locked memory care facility testified about the staggering and drastic change in his behavior, and that it didn't really align with what they typically saw from their patients. So the people who were taking care of him day in and day out as his competency hearing got closer noticed a marked shift in his behavior, which to them was not exactly their experience in working in a memory care facility. So we'll let the doctor continue to explain. Well, we'll let Law 360 tell us what the doctor explained. They go on to say right around the time Girardi's firm imploded in December 2020, multiple lawsuits were filed against him and federal prosecutors started investigating his activities. Yeah, in multiple jurisdictions. Girardi also reported at the time, or was also reported at the time by his attorneys and his brother, Jack Girardi, to be suffering from severe memory loss to the point he could no longer understand what was happening to his firm or grasp basic legal documents. He grasped that if he played the old man card, he might get some sympathy and get out of this. But you know what? We've got all those voicemails. This fucking dude. We've got all these voicemails from Girardi going back years being like, don't be mean to me. I'm a nice guy. Don't be mad at me. Don't be mean to me. But then when that doesn't work, there was a flip and there were threats in all of those voicemails from other attorneys, from clients. In all of this, it was, oh, but be nice to me. Oh, I'm a nice guy. Oh, I had to take care of my eye. And then it would flip to, I will go after you. And we heard all those voicemails, and the jury has heard some of them too. Let's see. But Darby, the doctor, said he determined Girardi was faking because just before December 2020, he was functioning normally. Just before the house of cards came crashing down, everything was fine, with occasional memory lapses. Okay, well, I'm very ADHD and in my 40s, I have memory lapses. So we're talking about an 80-year-old. Do we expect him to have some memory lapses? Yeah, we do. Does that negate the entirety of what he was doing? Not for me, it doesn't. He goes on to say, because Girardi does not have Alzheimer's, a rapid decline in his cognitive functions over 1 month would be atypical, he said, adding that those factors lead me to determine he was exaggerating or feigning the severity of his many problems because it might be beneficial. That's exactly what the judge said in the order finding him competent. The judge said, look, there's a lot of evidence of malingering here. There's a lot of evidence that in a month, he had a significant and swift change in the way he behaved. And that lines up with malingering more than it lines up with him actually having progressive cognitive decline. And for anyone who's dealt with this, I wonder if any of the jurors have dealt with this in their own life, because the behavior is enraging, right? So the doc's like, it led me to determine he was exaggerating or feigning the severity of his many problems because it might be beneficial. The doctor said he reached his diagnosis and conclusion by reviewing evidence in the case, statement of family and associates, and medical records, as well as videos and media appearances of Girardi in 2019 and 2020. Get this. Including behind-the-scene footage of The Real Housewives of Beverly Hills, which he appeared on sometimes with his then wife, Erica Jane, who is a cast member. Look, Real Housewives. Real Housewives has entered the chat. They're like, look, this is behind-the-scenes footage of Real Housewives. This is footage that maybe didn't make it to air that we have of Tom Girardi. So the doctor was also looking at his media appearances, his reality TV show, behind the scenes. Look, it seems like when the feds were like, hey, Bravo, what we're going to need is whatever hit the cutting room floor that has Tom Girardi in it. Bravo was just like, well, NBC Universal was just like, here, leave us out of it. Here you go, leave us out of it. So, look, doctors aren't going to diagnose from watching clips of somebody, but to be able to question that diagnosis and say, look, this is the behavior that we're seeing behind the scenes, when he's not on air, when he's filming reality. That's different. Is he having linear conversations? Is he having conversations about what's happening? How does he seem? Including his appearances. He was giving speeches to like bar associations in 2020 before all of this broke. The videos of Girardi, including one where he moderated a panel of other lawyers, showed him able to handle complex situations. Darby said, someone with mild of cognitive impairments can typically compensate for their shortcomings. I feel attacked. I feel so attacked. Me and all of my ADHD neurospiciness. Someone with mild cognitive impairment can typically compensate. How many of you have been trying to typically compensate for your brain for their shortcomings and still function well and work in social situations? The article goes on to say dementia or malingering. Darby agreed with the defense expert, Dr. Helena Chu of the University of Southern California, that MRIs show serious atrophy in parts of Girardi's brains, but said that the scans alone don't tell the story of cognitive abilities, and they need to be considered alongside memory tests, statements of people close to the patient, and other factors. Because we don't know. Like, we've heard all of the testimony, or we've heard about the testimony that Girardi had atrophy in parts of his brain, but we also don't know how long that had been there, and we don't know how long he had been dealing with it. The brain is pretty damn incredible. So if he already had some of that atrophy to start with, then that's his normal baseline. So you can't necessarily just say, oh, this change must be causing the issue. So you never know where he is and where his baseline was, because you just don't have scans of him dating back decades. So I agree with the doc. He's like, look, there's lots of factors that come into this particular patient. He also agreed with the defense doctor that Girardi's memory problems are likely caused by limbic predominant age-related TDP-43. I'm not even going to try. Or something called late. But he disagreed with the severity of the problem and that the memory problems could have progressed so rapidly in late 2020. Yes, the memory problems seem to have rapidly tracked with his legal problems. And when you see the memory problems and the legal problems going like whoosh, then it raises a few questions, doesn't it? Girardi showed little emotion as he watched the testimony about his mental state, which has been typical through the trial. Well, he did say "fuck you" to prosecutors during his hearing on competency. So I'm sure his attorneys are like, "Hey, that kind of indicates that you know exactly what's going on when you're mad about it. So maybe just sit there." They go on to say each day he showed up in court dressed in loose-fitting pants, an oversized gray sport coat, and white sneakers, a far cry from the days when he would make the best dress list in Los Angeles media. And we think that do we think that's anything other than intentional, though? He may have lost weight in the time that he has been in a care facility, but do we think that him not showing up to court dressed super sharp is anything other than him leaning into his defense of like, I'm a nice guy, be nice to me? That's exactly what that is. It's exactly what that is. There is a courtroom makeover that you will see with just about everyone in court, which is part of it. But you will see the choice, and this is an absolutely intentional choice. This is the be nice to me. I'm a nice guy. Look, you wouldn't want to prosecute your grandpa, would you? I'm not rich and highfalutin. I'm just stop it. Girardi's attorneys said at the end of the day that he might testify Thursday. We'll see, because if I wonder if that prosecution witness was called out of order, because we should be done with the defense case if the prosecution's calling their doctor, though of the witnesses that are often called out of order, doctors kind of fall at the top of those witnesses that are called out of order. So I don't know if we will see Tom Girardi testify. When you've got a client, and of course it's the client's right to testify, but when you've got a client who's accused of malingering, testifying is a real bad idea. Like, it's a real bad idea. But Tom Girardi doesn't strike me as someone who doesn't have a oversized or outsized ego. So will he be able to check his ego, or will he go full Murdaugh and be like, let me explain, be nice to me, and try to talk his way out of it? If he tries to talk his way out of it, he might talk himself right into a conviction. So we will see what happens. Will he testify? I don't think so. I think it would be a huge error if he does, but that doesn't. Murdaugh shouldn't have testified either, and he sure got up there and did it. So we'll see. These thieving lawyers, man, they're going to try to talk themselves out of all of it, but we'll see what happens today in federal court. I think they'll probably get to closing arguments. They haven't been having court on Fridays, so if the jury deliberates, they probably won't be deliberating Friday, but the court might allow them to deliberate and bring back a verdict on Friday. It just depends. So we'll see what happens. We are just about done with the Girardi case. I don't know how long the jury will take. There are 4 counts, and all of them are fairly similar, just to different victims. Presumed hostile said full Murdaugh. Will Erica testify? Erica will not testify. This case is almost done. She's not on the witness list. They are still married. Plus, there is a spousal privilege, so they can't force her to testify against him and what she did or did not see. So there is the Erica of it all only came into this case in relation to whether or not his company, Girardi case, sorry, I have cat fuzz. Of course I do. Whether or not money was going from Girardi Keese into her company. That's the only time she really came into conversation in this trial. So with all of it, we need to go to from Murdaugh. No, Girardi. Well, Murdaugh was this week too. From Girardi all the way to Donna Adelson, another defendant who I think really might testify. So Donna Adelson is one of those defendants that I could absolutely see testifying. Have you guys been following this story? Emily Jane has a great. Emily, your name is close enough to mine and Erica James combined that we have to answer this question. This is a great question. Let's answer this and then we'll move on to Adelson. Who gets to give up the privilege, the witness spouse or the defendant spouse? Either spouse can assert spousal privilege. So there are circumstances where this doesn't apply. In like divorce proceedings and stuff like that, there are some circumstances where this might not apply. But in this context of criminal court, Girardi could assert the spousal privilege to stop Erica from testifying. So it's not just that she could assert it, he could also assert it to stop her from testifying. So are we ready to move on to all of the Adelson everything? I think so. So for those of you that have been following this case, it has gone on for over a decade at this point. Donna Adelson may be one of the last prosecutions in this case. We're going to go through the statement of facts as we get into all these motions in limine, but as a very, very, very brief summary, Donna Adelson is accused of conspiring for the murder of her son-in-law. So her daughter's husband, the father of her grandchildren. Her son has already been convicted. Her son worked with middlemen to arrange the killing of Dan Markel, and all of the intermediaries, the middleman and the shooters or the hired gunmen, they have all been prosecuted. One pled guilty. I did a whole breakdown of the case a while back, where we kind of break all of that out. But the reason I'm not referring to everyone by name is because then it will start to get confusing. But you've got Donna Adelson, the mother-in-law, working allegedly with her son to kill her daughter's husband. Oh, my voice. Excuse me. Hold on one second. Oh, that's not the music. That was an error. Look, man, some days streaming while recovering from being sick is it's dynamic. We'll fix it in post. I didn't mean to get the horn in there. Now I'm hot. Being sick is the best. I'm just like, I coughed and now I'm hot. It's fantastic. I apologize for the air horns. So apologies for the air horns. We'll fix it in post. Okay. So Donna Adelson, the mother-in-law, is accused of conspiring with her son to kill her daughter's husband or ex-husband. They were going through a really contentious divorce. When I say family law can be some of the most dangerous cases, family law can get really bad really fast. So they had gone through a contentious divorce. There were issues over where the kids would be. It seemed that the Adelson family wanted the kids to be closer to Miami, Florida, not up in Tallahassee, and that there was issue with who would have the kids. And I don't think it's ever best for the kids when, family members conspire to murder a parent. I think that's always bad. Don't do that. So Charlie Adelson has been convicted. The go-between or the middleman who talked with Charlie and it seems with Donna and the shooters has been convicted. The shooters, one pled guilty, one was convicted. So everybody who's been arrested in this scheme has been convicted or otherwise sentenced if they pled. Wendy, the ex-wife and mother of the children, has not been prosecuted. She has a deal of some sort. We'll get into that as we get closer to trial. The husband of Donna has not been prosecuted or convicted. We'll see what happens with that. But as these prosecutions keep going, the earlier folks that were prosecuted are coming in and testifying and did in the last trial and will again in this trial, kind of spilling the tea on what everybody was doing. So with all of that, Donna has made a whole bunch of motions. She's getting ready to go to trial in September. So she has made motions to dismiss the case, to use a jury questionnaire. We're going to go through the questionnaire, to exclude her travel from discussion in trial, to move to a smaller courtroom. So she's got a whole bunch of motions in limine. So here's what's going to get confusing. When we talk about motions in limine, sometimes I refer to them as MILs, but she's also the mother-in-law of the victim. So when we're talking about motions in limine, I'm not talking about her as the mother-in-law of the victim, but she's also the mother-in-law of the victim. So with all of that, hopefully that is a good overview of what we're going to talk about. I think we're going to do the motion to dismiss first and then get into the motions in limine to exclude travel, the jury questionnaire, and the rest of it. I think that makes the most sense for us because the motion to dismiss will have a better overview of the case, and that will get us where we need to go. And then if I need to just put this up on the screen and blow my nose, then we'll do that too. So let's talk about these motions in limine and the motion to dismiss. We're going to talk about the motion to dismiss first. So this is defendant Donna Adelson's motion to dismiss. Let's go ahead and get into that. Everything that we're looking at was filed on August 12th. That was the deadline for all of the motions. We have some of the state's motions too. They're not as illuminating as to what is being argued because the state is just like, we've done this case 100 times now, so it's fine. So the state motions aren't nearly as illuminating for us as what Donna is arguing. Defendant Donna Adelson's motion to dismiss the indictment. Girl, good luck. I mean, good luck with this. All right, let's. It just doesn't. It's just gonna bug me that it's all right. It's gonna have. Can we just scooge a little bit, just so we're right there? All right, we're gonna have to. The document and I are gonna fight all day long, but it's going to be fine. All right. Defendant Donna Adelson's motion to dismiss indictment for pre-indictment delay or alternatively to exclude evidence. Keep in mind, with all of this, the statute of limitations for murder is none. So, sure, Donna. Defendant by and through counsel pursuant to Florida Rule of Criminal Procedure 3.190 and the Due Process Clause of the Fifth Amendment respectfully moves this court for an order dismissing the indictment for pre-indictment delay or, in the alternative, precluding the state from introducing exhibits or testimony at trial that she can no longer adequately refute because of the state's charging delay. The state can charge whenever they want. Look, man, when it comes to murder, there is no statute of limitations. This case presents an egregious example of pre-indictment delay. The state began its investigation with Miss Adelson among its prime suspects just hours after Professor Markel's murder in July 2014. By 2016, the state had focused its effort through witness interviews, document subpoenas, pen registers, surveillance, undercover operations, and wiretaps to charge her alongside her alleged co-conspirators. In fact, the state's evidence against Miss Adelson has remained largely unchanged since then. And yet, the state made an intentional strategic decision not to charge Miss Adelson for almost 8 years. And choosing instead to pursue charges against 4 of her purported co-conspirators first. When the state finally decided to seek an indictment against Miss Adelson, more than 9 years had passed since the murder. Okay. By that point, exculpatory documents critical to her defense that the state never saw fit to obtain, including cell phone records to refute the state's call pattern claims and SunPass records to refute the state's unsubstantiated and inaccurate suggestion of a money drop, were lost to foreseeable document retention policies. A lot of those are like 7 years, but some of them are much, much less, causing substantial prejudice to her defense. Accordingly, the indictment should be dismissed as a violation of Adelson's due process rights. I mean, I understand why they're arguing. They kind of have to. I don't think it's going to really go anywhere for them, but they kind of have to. They say, but if the court is unwilling to do so, arguendo, like we know, we're going to throw the Hail Mary, and then we're going to say, but if the court's not inclined to do that, at a minimum, it should preclude the state from introducing evidence that Miss Adelson can no longer defend against because of the state's charging delay. Background. So here's our summary from the defense perspective. Professor Markel was murdered on July 18th, 2014. Within hours, the state located his former wife, Wendy Adelson, and brought her to the Tallahassee Police Department. During the hours-long interview that followed, Wendy confirmed that she and Professor Markel had been embroiled in an acrimonious divorce and that her parents, her mother included, were, quote, very angry at him. From that moment on, Miss Adelson was one of the principal targets of the state's investigation. Over the ensuing weeks and months, the state, joined by the federal government, devoted substantial resources to its investigation to support its theory that Miss Adelson was part of a murder-for-hire conspiracy. The state questioned witnesses at length about Miss Adelson and her relationship with Wendy and Professor Markel. It subpoenaed and combed through Adelson's personal and business financial records going back to January 2013. I mean, a year and a half back. It reviewed hundreds of emails between Miss Adelson, Wendy Adelson, and Charlie Adelson. It reviewed Adelson's calls and text messages, having filed applications with the court to obtain call detail records. I mean, the call detail records from 2014 are not nearly what they are today, but I digress. To obtain call detail records for cell phones belonging to Wendy, Charles and Harvey. I'm going to keep calling him Charlie because it's confusing to me that we are going back and forth and back and forth. Although it says, curiously, a similar request was not made for Miss Adelson's phone. And of course, in 2016, they probably didn't have, I would imagine the reason they didn't get the cell phone records for Donna at that time is because they might not have thought they had PC to get it. Anyway, it goes on to say, of course, in 2016, it conducted in-person and wiretap surveillance of Donna Adelson as part of a month-long undercover operation known as the Bump. Bump. This was them trying to bump somebody into confessing to something. We're gonna give it a nudge. By May 2016, the state had in hand virtually all the evidence it's likely to present when Miss Adelson's trial convenes next month, almost a decade later. But the state did not charge her in 2016. Instead, it made the strategic decision. And I say it like that because that seems like the voice for the bold and italicized strategic decision to pursue charges against the shooters and Miss I can't pronounce her last name well. Magbana? No, that's going to be wrong. Magbana? I'm not going to pronounce it right. She's the middleman. So they pursued the shooters and the middleman first, and then they pursued Charlie. So shooters and the middleman, hoping they would plead guilty and reveal what the state believes was Miss Adelson's involvement, but that did not happen. And so Miss Adelson remained uncharged through 2 trials, one in 2019, another in 2022. The state also failed to charge Miss Adelson when it charged Charlie Adelson in 2022. Once again, the state chose to delay or strategically wait until they had everybody else prosecuted. So that, once again, the state chose to delay. There's no statute of limitation. They can just do what they want. It wasn't until after Charlie's conviction, with no new evidence to bolster its case, that the state brought charges against Adelson in November 2023, 9.5 years after the professor's murder. They say death. I say murder. People have been convicted of murder. We're calling it a murder. Discussion. The state's 9-year delay in charging Adelson warrants dismissal under the Due Process Clause. Okay, the Constitution's recognized inherent in the right of every criminal defendant is a fair trial and the right to be charged by indictment or otherwise in a timely manner. While statutes of limitations are the primary guarantee against bringing overly stale charges, they do not fully define defendants' rights with respect to events occurring prior to the indictment. They say that the Due Process Clause of the Fifth Amendment plays an important role in protecting defendants against oppressive delay, operating as a safeguard against actual prejudice to the defendant that comes with the passage of time. Well, but people have testified. It's not like this case has been silent and then all of a sudden it's here. It's been testified to over and over and over again. So it's not as if nobody's testified in this case. There's been the 2 shooters, the middleman, and Charlie. There's been 4 prosecutions. They go on to say Adelson is substantially prejudiced by the state's 9-year charging delay. We anticipate the state will present evidence through Tallahassee State Police Sergeant Christopher Corbett of calls and text messages clustered around the events of obvious significance to the murder in July 2014 and what the state has characterized as the first murder attempt in June 2014, and opine that these clusters, which include communications to and from Donna, are consistent with her participation in a murder-for-hire conspiracy. The problem with the state's theory, however, is that its sample size is far too small and biased. That is, the state's analysis only included cell phone activity between May 2014 and July 2014. Had the state looked at a broader time period, one that began in 2013, for example, or even earlier, it would have seen a similar call pattern clustered around dates and events that had nothing to do with Professor Markel's murder. These earlier patterns would prove that whatever Miss Adelson's communications were around the time of the murder, they were part of a large pattern of calls and text messages between a mother and her family, not a murder conspiracy. I mean, you can cross-examine all of that. But the state never sought to acquire call detail records for any period before May 2014, although it easily could have done so the same way it obtained Adelson's financial records dating back to January 2013. Since Adelson's indictment, we have attempted to gather those records and they no longer exist. Predictably, none of the private cell phone carriers retain records from a decade ago. Equally, if not more prejudicial, the state will likely argue that on the night the professor was murdered, Donna drove to Charlie's home for a, quote, money drop. Never mind that Charlie had previously acknowledged that the money paid to the middleman that night came from his bedroom safe. Because that's okay. The state likely still will speculate that this fictitious money drop occurred. I mean, that's for cross-examination. And it will attempt to bolster. I mean, they could have Charlie testify. Bring Charlie in. Can you imagine? Like, bring Charlie in to testify. So, bring Charlie in to testify then. They might too. He still has a right against self-incrimination, but he did testify at his trial. He's on appeal, but he could come in and testify and be like, no, there was no money drop. My mom didn't do nothing. This is why we're going to watch this trial. This will be interesting, won't it? It said, let's see. The state will likely speculate about this fictitious money drop and will attempt to bolster its guesswork through a single text message sent from Donna to Charlie on July 18th, which reads, outside your house. Well, what does that mean? If not outside your house. Okay. Once again, the state is wrong. The state is wrong. The theory doesn't hold water. Emily, you've gone full Marissa Tomei. I could never do it as well. Miss Adelson was never at her son's home that night. Instead, she and her husband were driving from Miami to Tallahassee to be with their daughter and grandsons in the wake of the shooting. Okay, well, what time did they arrive there? Have that testimony then. You can rebut this with testimony. Records from Adelson's SunPass transponder would easily prove that, but the state failed to obtain those records and the defense cannot. That's a bummer. I mean, that's a bummer. The state served multiple subpoenas on the Florida Department of Transportation for SunPass records related to Sigfrido Garcia and Luis Rivera. Those are the shooters. But the state, aware that Adelson routinely drove between Miami and Tallahassee to visit her daughter, including the night of the murder, never tried to secure similar records for Adelson. I think that there's room for them to argue about that. And there's room for them to say, hey, this can't come in where she was or where she wasn't because you didn't obtain it. But all right. They say they never tried to secure it, but this is also great cross-examination for the detective. Hey, detective, you didn't even secure any of this, and argue that the state's overreaching. Like, you can see that argument on cross-examination. You didn't do this, you didn't do this, you didn't do that. So you can argue everything the state didn't do. It's not going to get the case dismissed, but there is room to try to limit what the state can say based on the fact that they can't go back and obtain this evidence because it wasn't preserved at the time. I think there's room to argue that. So I think there's room to maybe limit some of those arguments from the state, but this is all great argument for cross-examination, right? Steve asked in the chat, why is any of this the state's responsibility? Steve, what the defense is arguing here is that the state essentially cherry-picked what evidence they were going to seek in the months after the death. And because they didn't charge Donna for almost 10 years after the murder, if the state didn't grab the evidence then, it's all essentially destroyed at this point. So the Florida Department of Transportation doesn't still have all of the transponder records from the Pass or whatever it is. So I imagine there's probably a toll road or something. So it doesn't still have those records that would have shown when that transponder was registering travel, though there's always an argument that you could hand, if it's a physical, like the ones in California used to be a physical little thing, you could hand it to somebody else and they could use it. So then the defense would have to prove it was in her car, which how do you prove it's in her car? So they're arguing that because the state didn't preserve this evidence, it's gone. And now the defense can't go obtain it because it's so many years later, those records have been destroyed. So that's why they're arguing, that this shouldn't be allowed in, because when the state got all this other evidence, if they had preserved this, then they would have a better case to argue. This is really all argument for cross-examination with that. So they're saying that the state could have easily obtained it at the time. And that's why they're saying, look, you knew that Donna Adelson was perhaps a target here from that first interview, because the state's not arguing we didn't know. They're arguing now that they could have done it back then. So I see a lot of you saying SunPass collects tolls by plate or transponder that is stuck on the windshield. Was that the case in 2013? Was that 2013? Because in California, they're there now, where their stickers are by plate, but back in the day, they were like a physical transponder. So some of you guys are saying, yes, they were stickers back then. So that makes it harder to shift it, but and harder to argue. But does that mean she's in the car? Is somebody else driving the car? So there's still, just because they have the records doesn't mean it's as cut and dry, unless you have somebody like running a red light on red light camera and you can see that it's them driving in the car. You can still argue that, they weren't the one driving the vehicle. But again, the defense has every right to argue, look, you should have preserved all of this evidence and you didn't, and it's unfair to the defendant because now the defendant can't go back and get evidence that might have been helpful to their case. It might not have been helpful to their case, but they don't know because they're saying it's 10 years later and we can't go get it by the time that she was charged. So that's what she's arguing for, and that's why they're saying, look, Wendy was talking about her mom being mad in the initial interview, like the night this happened. So, all right, let's see. For those of you in Florida, Neurocystic said, Emily, I got my first sticker in 2010 for perspective. Perfect. It's helpful to know. So they might have had more information back then, and that's what the defense is arguing here. So there are, again, there's no statute of limitations for murder. It's a different conversation, I think, because some murders go unsolved until you have advances in DNA technology or a break in the case that comes 15 years later. But I think the argument here is a little bit different, or there's room for the argument to be a little bit different because she was identified as a target. And so from the time she's identified as a target, she's arguing they knew and they could have preserved this. It's not like they had no idea that she was a potential suspect. They knew and they chose not to charge her, which under the laws as they are today is their right to do. So whether that is fair or not to her is what she's arguing. They go on to say, moreover, had Donna been charged in a timely manner, she would have been able to obtain these records, which would have ruled out any possibility that she stopped at Charlie Adelson's residence. Well, yeah, they might have to do it a different way. It goes on to say the records would have shown time and location entries of her vehicle on the turnpike, which would have shown that the state's dangerous guesswork is wrong. So this is why their backup argument is like, hey, if you don't dismiss the case, then the state shouldn't be allowed to argue this because we don't have the records, so you can't argue this information. Now, did the state try to get those records? Did they not try to get those records? I don't know why they wouldn't get those records when they're pulling everybody else's records. So we'll see what the state has to say. Diane said she knew and could have preserved it too. She would have had to have gotten a court order, which might have been difficult. I don't know. Maybe she could have if she had. I don't know what your accounts would show if you're using SunPass, but could she have saved her SunPass records in some way? Yeah, I mean, she could have printed them out, I guess. Would the state have argued down the road, well, we can't verify the authentication of those? Maybe. But if the state tried to pull them, then, we'll see. The defense is saying the state never, ever tried to pull them. And so then there's, they don't exist any longer. Some of you in the chat are saying those records didn't exist. And if they didn't exist, then the state is going to just argue that and say, these records never existed. We tried to pull them at the time and they just weren't there. They're going on to say, in the due process context, the substantial prejudice requirement is met where the state's pre-indictment delay renders key exculpatory evidence unavailable. But you don't know it's exculpatory, right? Because you don't have it. But they're saying it coincides with Donna's statement about what she was doing, which if Donna wanted to testify, that's the only way this comes in. If Donna wanted to testify, hey, I was driving and here's my transponder records, then that gives a little bit more substantiation. Excuse me. So it's going on to cite cases saying that a murder conviction was reversed after concluding that a 7-year plus delay in the prosecution, during which records that would have supported the defendant's alibi were lost or destroyed. So they are citing Florida case law that supports their position. Another case, State v. Ellis, finding trial counsel ineffective for filing to seek to dismiss based on pre-charge delay where potentially I bet they mean failing. I bet that's a typo. Finding IAC where the defense failed to seek a dismissal based on pre-charge delay, because otherwise that doesn't make any sense, where potentially exculpatory surveillance video recordings were destroyed. Finding actual prejudice where exculpatory evidence was lost due to the passage of time. And again, you have to show that it's exculpatory evidence, and that's difficult. They go on to say the state's charging delay in this case has done just that. It's crippled Adelson's defense because the only documents capable of undermining the state's theory, SunPass records and call detail records prior to May 2014, are no longer available, lost to the passage of time. Footnote 1. Oh, let's see what they have to say in footnote 1. The state may argue that Ms. Adelson is merely speculating about what the SunPass and cell phone records might have shown had they been preserved, and that the speculation does not give rise to substantial prejudice. It's hard to talk today. Lies every day. But as the third DCA has held, quote, a negative inference cannot be drawn against a defendant based on the state's failure to secure evidence. That's from State v. Ellis. Also, the records absolutely would have shown her time and location and entrance on and off the turnpike in question, showing that she could not and did not appear at her son's house on the evening of July 18th, 2014. I'm interested to hear what the state has to say in response to that, because under the case law they're citing, and they are citing numerous cases where the court found prejudice when evidence was lost due to the passage of time. It would be interesting to see, because in this case, the state was aware of Donna Adelson from the beginning of the case. So I want to see what they have to say. What they might have to say is, we tried to get the evidence and it didn't exist. So it's not exculpatory. It never existed. So there's no delay. It just wasn't there. The state's delay in charging Adelson was in bad faith. It goes on to say the second part of the due process analysis requires a showing that the state's pre-indictment delay was a product of bad faith. Bad faith in this context does not require a subjective, sinister motive, but on the part of the prosecution. Rather, it's satisfied when the government makes a judgment about how it can best proceed with litigation to gain advantage over the defendant. As a result of that judgment, an indictment is delayed. They definitely made a choice. Right, they chose not to indict her, and that's why the defense is arguing that they knew that there is not substantially new evidence. It's not like something changed that allowed her to be prosecuted now that didn't exist before. So they're arguing that's precisely what occurred here. Rather than proceeding against every member of the alleged conspiracy at once, the state sought separate, staggered indictments, betting that the earlier charged defendants would implicate Ms. Adelson. They go on to say none did with regards to Ms. Adelson, and an indictment against Ms. Adelson did not follow for another 9+ years. This was not an investigative delay of the sort sanctioned by the Due Process Clause. Virtually all of the evidence the state is likely to present against Adelson was in hand long ago. The state's charging delay was strategic and in blatant disregard for Adelson's ability to defend herself. They go on to cite United States versus Foxman, noting that the court should have little difficulty in preempting or permitting the foreseeable of a deliberately chosen foreseeability of a deliberately chosen litigation strategy to be visited upon the government. There's something, it seems like there's something missing in that sentence, or I'm just still not all the way healthy, but it seems to be that Foxman was saying to the court, if the state fucks around, sometimes they need to find out. So if the state is delaying on purpose, and that is to the detriment of the defense, then they need to find out. Yeah, I think that is what they are trying to say, but it is a really fucking awkward sentence. It feels like there's words missing, and it's not just my brain. Should the court decide not to dismiss the case, I think it's probably unlikely that this will be dismissed. Should the court decide not to dismiss the case, the court should preclude the state from introducing evidence that Adelson cannot refute because of the state's charging delay. I think this is probably maybe not their preferred argument, but their more reasonable argument. Should the court determine the state's charging delay does not warrant dismissal under due process, it should prohibit the state from leveraging its delay by admitting call pattern and text message evidence that Adelson cannot adequately address and refute. They're saying because she can't go back and get the text records because they're 10 years old. It'd be interesting to see what records the state does have. And could they have gone back and gotten more records? Maybe. But then I'd also need to see the warrant, and the court's going to have all those arguments when the state responds. And this is all going to come to hearing before the trial in a couple weeks. So we'll see then. They go on to say fairness dictates that the state should not be allowed to present call pattern and text evidence to a jury without determining to a jury tasked with determining Adelson's fate when, because of the state's delay, evidence that would refute the state's claim has been destroyed. The court's going to say that's all for cross-examination. Conclusion, the state's tactical decision to wait 9 years after Professor Markel's murder to indict Donna has substantially prejudiced her ability to defend herself. She can no longer obtain material exculpatory evidence concerning call patterns and her location the night of July 18th, a foreseeable consequence that the state took no steps to mitigate. Accordingly, the indictment against her should be dismissed. It'll be really interesting what the state will argue here. I jumped into this case as Donna got indicted, so I'm kind of waiting for all of the information to come out with regard to Donna. Pettycakes in the chat asked a great question. Does this show the defense's hand, though? The state knows the defense's hand. They're getting ready for trial. The state knows what they've been with this case for almost a decade, and they've gone through the trials of the shooters, the middleman, and Charlie Adelson. So the state absolutely knows what's coming. So yes, it does, but it's not a staggering reveal here. They know what these arguments are going to be. And the defense needs to make these arguments now because this is the time to try to limit the evidence against her, and limiting her text messages. Look, she's charged with conspiracy to commit murder. If she's dropping cash, that is an active participant in a conspiracy, more than just like a lot of phone calls to her son the night that her grandchildren's father dies. So those phone calls can be explained as or argued, I guess, as this family was trying to figure out what was going on and if anybody else was being threatened, or if anybody else had been harmed, or what was going on, how the grandkids were. Like, there's a lot of reasons a family might be on the phone quite a lot that day and in the days after that can be explained. But the state is trying to show that she was an active participant in a conspiracy to commit murder, and arguing that she was doing a money drop is going to be one of the things to show she was an active participant, not just like a concerned mom calling her son. So they're trying to limit that. argument from the state, and that showing or arguing that she was dropping cash. So let's get to our next motions, shall we? What should we go to next? Should we talk about her fleeing the country? I'm sorry, her travel. Should we talk about her travel? In other content, we have together watched the body cam footage of her being arrested at Miami International Airport. So we're going to look at how that travel was not, in fact, her fleeing the country and why the defense wants to keep that out. So let's talk about Donna Adelson. Are we traveling or are we fleeing? Let's see what the defense has to say about that. This again comes to us on August 12th because that was the day that all of these motions were due. This is defendant Donna's motion to preclude evidence of her travel as consciousness of guilt. Flight is one of those things in the evidence code where flight can be used as consciousness of guilt. So it's not unusual that flight gets used, and it's not always a traditional like get on an airplane flight. It can just be like running away. So this is one of those things that's allowed generally to be argued as consciousness of guilt. They go on to say, Donna Adelson, through counsel, is moving to foreclose the state from arguing her attempted travel to Vietnam after her son's conviction, and nearly a decade after she was first named as a suspect in an unindicted co-conspirator, constitutes consciousness of guilt. What was her return ticket then? When was she coming back from Vietnam? I have questions. Why was she getting things in order? I have so many questions. Emily, do you think she was fleeing? Yes. In a lot of cases, I'm like, I don't know what that was. In this case, do I think she was fleeing? I absolutely do. I'm open to seeing what the defense has to argue, but I absolutely think she was trying to flee. Professor Markel was murdered on July 18th, 2014. Within days of the murder, Donna Adelson was a prime suspect of the state. And in August 2016, the state organized an undercover operation against Donna known as the Bump. Bump, bump, bump. We're never going to get tired of that. I didn't realize that the undercover operation was referred to as the Bump, but for all of you that put in the chat kickball change last time, thank you. We might have to play just a brief clip of that at some point for all of you that are like, what in the Reno 911 is happening here? Yes, on and on. Anyway, the undercover Bump operation, which made it clear to Miss Adelson that she was a major target of the state's investigation. Yes, she was. This became even clearer after the arrests of others over the many years and the release to the public of the state's theory of the case, which put Donna, in the center of the state's conspiracy theory. In all that time, Donna traveled all over the world, including to countries without extradition, and always returned. It was not until after Charlie Adelson's conviction. I mean, did she always have a round-trip ticket, though? It was not until after Charlie Adelson's conviction in November 2023 did the state arrest her upon boarding a flight to Dubai with the ultimate destination, Vietnam. Because of the time and manner of travel as described below, this evidence should not be permitted as evidence of consciousness of guilt. Sure. Where prosecutors run into trouble in presenting evidence of flight to a jury is where the inferential chain between flight or concealment and consciousness of guilt is so attenuated to not be reasonably left to a jury for fear of prejudicing the defendant or drawing unnecessary attention to a likely meaningless act. Chat, you're going to have to tell me if this is a likely meaningless act. Excuse me. Apologies. You're going to have to tell me if this is likely meaningless. Oh, we need music. Give me 1 second because we're going to cough more. At least I got it right that time. All right. Let's see. They're saying that this could leave the jury to draw unreasonable conclusions. Here's the thing, though. There's also jail calls that give like context to the travel, but we're going to talk about those in a minute because they're also arguing that the jail calls couldn't come in. So there's more here. But wait, there's more. Hold on. Emily, what's the worst part about being sick? Well, there's a lot of terrible parts. I don't love being sick for sure, but the inability to regulate temperature, it's like we're hot, we're cold, we're hot, we're cold. So Wolf Chiara said motion to listen to the jail call. I covered it in a podcast episode, so I don't know if we need that, but I'll link that episode down below. So if you guys are interested in listening to the episode where we break down that jail call, I have it for you. I don't know if I'm going to have the bandwidth to do it today after all of these motions because sick. So we have those, and we're going to go through the motion to exclude the jail call after we do this. So they're saying the cases in which flight evidence has been held inadmissible have contained particular facts which tend to detract from the probative value of such evidence. They go on to say or to argue where there is little physical evidence linking the defendant to a crime, as is in this case. This type of flight evidence needs to be looked at more carefully. They're like, look, man, she didn't flee in 2016, so to say she's fleeing now is too tenuous. And then they go on to cite what the Florida appellate courts have said about it and a 4-part test to determine whether to exclude flight evidence. The state's going to argue this, and part of their argument is going to be, but listen to what she said about it. Listen to what she had to say. They go on to say, generally, the analysis for flight evidence frames the 4-part test in this way. Circumstantial evidence suggesting consciousness of guilt usually invites 4 inferences. First, the observed behavior suggests flight, like boarding a flight without a return ticket. Second, flight suggests a guilty mind or conscience, which may mean nothing more than a desire to avoid detection, rather than any feeling of remorse or sense of wrongdoing. Third, consciousness of guilt suggests that a person is conscious to his involvement in a charged crime as opposed to some other fact. Fourth, and finally, consciousness of guilt of the charged crime suggests actual guilt of the charged crime. Each inference depends on its own general premise or even hypothesis. However, this chain of inference breaks when the defendant can provide an alternate explanation for the flight other than consciousness of guilt. So they're saying, Your Honor, we can show you that there are other reasons for this spontaneous travel on a one-way ticket. It's not consciousness of guilt. She didn't she wasn't trying to escape law enforcement by any means. She was just really, really hankering to leave the United States right then, right after her son was convicted, and after they were talking about their plans on a jail call. Your Honor, it's perfectly reasonable. Let's see. So they go on to say evidence of flight is inadmissible when there are independent reasons for flight, as those independent reasons tend to break the second and third links of the chain. And then they go on to talk about a Mississippi Supreme Court case. In that case, the defendant had escaped from prison. Well, there's a lot of flight there. When law enforcement arrived at his home 2 days after a murder occurred, he fled the scene. The state attempted to omit evidence of his flight to show consciousness of guilt for murder. They were allowed to. He was found guilty. The court overturned the ruling. Based on the unique circumstances of his case, the court found that the flight may have been probative of his knowledge of the murder, but equally, if not more probative, of his desire to remain out of prison as an escapee. Well, that's a wild chain of events. You escape from prison and then he gets popped for murder, and then they're like, he's fleeing because he's guilty of the murder, and the court is like, well, or he's fleeing because he doesn't want to go back to prison because he's an escapee from prison. This is not the case here. Unless, Donna, is there something else that we need to know of? What is the other thing? Because here it seems that there's just the one thing. So let's see. Here the evidence is clear. Oh, good. Here the evidence is clear, even in the jail calls that the state marked as evidence. that Donna Adelson was not fleeing and was not leaving because she had a guilty conscience about being involved in the murder of Professor Markell. She did not hide her travel. She applied for a visa with the State Department. She spoke to about her travel openly with friends. A ticket was booked in her name, not an alias, at her local airport. She used her own passport. Your Honor, she wasn't hiding that she was leaving. She was talking about hoping to get out in time on a jail call, but maybe she was talking about the weather. Indeed, her travel was open and notorious. Moreover, and possibly more significant, if Donna was fleeing because of a guilty conscience, she would have fled nearly a decade ago when it was clear that she was the main target and suspect. Your Honor, she didn't run earlier, so why is she running now? She would have fled when the trial of the middleman, when the state made it clear that Donna was the centerpiece of the case. She would have left when Charlie was arrested in April 2022. The fact that she stayed here, traveled abroad, and always returned weighs in favor of finding that her November 2023 trip, years after the murder and years after Charlie's indictment, stemmed from a guilty conscience and not some other innocent reason. Well, what's the other reason? The United States Court of Appeals for the 11th Circuit has said on multiple occasions that the probative weight of such flight evidence is diminished if there has been significant time delay between the commission of the crime or the point at which the accused has become aware that he is the subject of a criminal investigation to the time of flight. It's a solid argument. Her jail call might refute that argument, but it's good use of case law in their argument saying, hey, she had a decade that she knew she was a subject in this. But then again, her son being convicted seems to have maybe made it real. And it seems to me that maybe Donna's looking at the middleman and the gunman as separate from her. Like she's not seeing herself aligned with them. But once her son went down, she was like, oh, fuck, shit just got real. And the people that we hired to keep us out of the fray, allegedly, well, that Charlie hired, that's been proven, maybe we're not as distanced from this as they thought. Because once Charlie get convicted, it was like, oh shit. So maybe. They're saying this case could not be more instructive to the court's decision. They're saying, Your Honor, follow what the 11th Circuit said and look at how much time has passed. Here, the time delay between when Donna Adelson became aware she was the subject of the investigation and, in fact, an unindicted co-conspirator of the state's investigation, and when she attempted to travel to Vietnam is so significant as to render the flight evidence not probative of her guilt. They are totally silent to everything she said in the jail calls. They're like, but Your Honor, she didn't run before. And I think the state's counter to that is going to be, yeah, shit didn't get real until her son got convicted. When her son got convicted, shit got real. And that's when she decided to run because she thought she was untouchable. If I was the state, that's what I would argue. Finally, because the evidence against Donna at her trial is solely circumstantial, this flight evidence should be excluded. There's a real fear that the jury will overvalue this evidence and convict based on the flight evidence alone, which would be improper and grounds for reversal. Your Honor, no one wants to get reversed on appeal. Don't let it in. As such, we ask that it be excluded. Footnote 1. We have confirmed with the state who opposes this motion. We have conferred with the state who opposes this motion. Of course the state opposes this motion. The state's like, we arrested you with a one-way ticket after your jail calls, which means we have to talk about the jail calls next because it seems like that's the place to go. Let's see. There we go. All right. This is the right motion. We need to talk about the jail calls because the jail calls give context to the flight to Vietnam. Again, I covered that in a podcast. We will link the podcast down below if you want to hear the jail calls for yourself or anew for the first time or a refresher. That will be there. Let's talk about Donna Adelson's MILs, the motions in law. No, it's motions in limine. Motions in limine. These are the pretrial motions to exclude shit. Your Honor, the jury shouldn't hear this shit. That's what these motions are. Your Honor, this is shit we don't want the jury to hear. I am out of water in my lawnard. I love this tumbler. I am out of water in my lawnard tumbler. We have finished the coffee. We are rolling on the second glass of water. We got to stay hydrated. We are under the weather. All right. Defendant Donna Adelson's motion in limine. Defendant through counsel brings these motions. Testimony concerning pre-arrest silence. I don't know what the state would seek to introduce here. I'm really interested to see what they think the state would seek to introduce here. During the 2019 trial of the middleman and the shooter, the state elicited testimony from Tallahassee Police Department investigator Craig Issam. I don't know. The state elicited testimony from former Tallahassee Police Department investigator, we're going with Craig, that at Markel's July 24th memorial service, he asked Miss Adelson if she and her husband would submit for a police interview. Well, I don't love that. You come up at somebody, like rolling up at somebody's memorial service being like, hey, do you want to come in and talk to the police? I don't love that. I don't love that. Miss asked Adelson and her husband if they would submit to a police interview, but Adelson left Tallahassee without doing so. This testimony offered through the investigator or otherwise constitutes an improper use of her pre-arrest silence. I don't disagree with that. Under both the Florida Constitution and it must be excluded. Footnote 1, we understand that a person's pre-arrest, pre-Miranda silence may be used to impeach a defendant if they testify at trial, but only if the silence is inconsistent with the defendant's testimony at trial. I don't think that they're going to be able to use this in her trial. Saying, hey, do you want to come have an interview? And then bouncing on the interview is commenting on their right to remain silent. I think this will probably be kept out. I think it should be kept out. But it did come up in another trial, but it wasn't being used against her at that trial. So I don't think you can bring this up unless she testifies and is like, I tried to tell y'all. And they're like, really? You tried to tell us? But even, we've seen prosecutors tread this line badly. If she testifies and then they say something like, this is the first time we're hearing of this, you can't ask about that. Defendants are allowed to give their side of the event for the first time in trial. So I think this will stay out. I don't think this is going to be hard to the court to reach this conclusion that will stay out. Wealth evidence. During the previous related trials, the state presented evidence through financial investigator Mary regarding bank and investment accounts held by Miss Adelson and her husband by Charlie Adelson and their respective businesses. Such evidence has no relevance in the case at hand and is being introduced to inflame and prejudice the jury. They're rich, burn them at the stake. I don't think that's where this evidence comes in. With what I know of the case, money is being paid. So let's see what the defense has to say about that. Let's be clear. Oh, please, let's be clear. Let's be clear. We do not dispute the monies paid to the middleman in the wake of victim Professor Markel's murder were, in fact, Charlie Adelson's money. We do not dispute that the Adelson Institute had sufficient funds to pay the middleman bi-monthly. As a result, the state's so-called wealth evidence bears no relevance to Donna Adelson's case, and it's unfairly prejudicial and inflammatory. They have to show where the money came from. It's a murder for hire case. So that's going to have to happen. Let's see. And then they cite U.S. versus Bradley, stating that evidence of a defendant's wealth may be admissible when relevant to issues in the case. And it might come up here in the payment. Footnote 2, we have conferred with the state on this motion. The state does not oppose it. Where's the footnote 2? Oh, footnote Footnote 2 I saw late regarding the testimony concerning pre-arrest silence. Yeah, of course the state doesn't oppose it. You can't enter that evidence. You can't do that. So I'm not surprised that's going to get granted. And the state's like, yeah, we weren't intending to because, we can't. So wealth evidence, they're saying it's too prejudicial and it's trying to inflame the jury. As such, any evidence concerning Adelson's personal wealth should be excluded. Let's see what footnote 3 says. We have conferred with the state on this motion. The state opposes it. Yeah, she has money to pay for all of this stuff. They're going to want to bring that in. Hearsay testimony from Jeffrey Lacoste. Okay, Jeff, we're going to go with that. Jeff, the former boyfriend of Wendy, has been called to testify on behalf of the state in each of the last 3 trials. In every trial, Jeff claimed that at various points during their relationship, Wendy made statements conveying statements that Charlie purportedly made to her. Okay, how is this coming in? Among other things, according to Jeff, Wendy told him, 1, that Charlie said that buying her a television was cheaper than a hitman. 2, that Wendy said those in police interviews too. 2, that Charlie Adelson said that he looked into the possibility of hiring a hitman to address the Markel problem. 3, that Charlie Adelson described the dinner he and Wendy shared following the professor's murder as a celebration. Odd. And 4, that Charlie said he kept large amounts of cash in his home. The statements are hearsay within hearsay for which there is no exception under Florida law. I'm curious how those came in, actually. Because if they've come in, there's been a reason they've come in. I'm just curious as to how they've come in. So additionally, they say, and separately, their admission, if Charlie is unavailable to testify, would violate Adelson's Sixth Amendment right to confront and cross-examine, which raises an interesting question because in Charlie's trial, if they were used against him, and they said they've been used in all of the trials, if they were used against Charlie in his trial, it's a statement of a party opponent. But I understand their Sixth Amendment argument. Like, this is Charlie's statements to his sister, and his sister made those statements to her boyfriend. And now we're in like, heard it from a friend who, we're now well into, Charlie said to Wendy and Wendy said to Jeff, and Jeff is telling the jury. So I'm interested to see what happens with this. Of course, the state opposes it. If they've used it in all the other 3 trials, I'm curious how this has come in. Really interested to see how the court rules on that and what hearsay exceptions they use here, because my brain is like, wait, what? That's a lot. They go in addition, or they go. And then we go, and then she goes, and then he goes, and then we all go. I'm like, oh my God. The motion continues. Emily, just read it in Valley Girl. It's fine. They go, oh my God. I can't believe you would try to use what Charlie told Wendy against like his mom. Ew. All right. The motion continues saying, insomuch as these alleged statements relate to Charlie Adelson, the state should be precluded from eliciting them either through Jeff or through Wendy. Well, it's a little different through Wendy, but they go, they are of no probative value to Donna, and any probative value is substantially outweighed by the danger of unfair prejudice. But if they're co-conspirator statements and you remove Jeff from the equation and you get to Wendy, then they are co-conspirator statements made by Charlie, and co-conspirator statements might be able to come in, but we'll see. So we'll see. We'll see. Let's see. Footnote 4. Your Honor may remember that in Charlie's trial, the court granted the first part of this motion. However, they're going to answer the question for me. Thanks, defense team. However, the state was allowed to question Wendy Adelson about these topics, and the state was able to then impeach Wendy Adelson by asking the same questions to Jeff. Well, that's different. That's different. That's how they came in. They came in as impeachment, and they came in against Wendy as a prior inconsistent statement. So, right. So okay. Emily, back up. So the state in Charlie's trial had Wendy testify. When Wendy said, I didn't say any of that. Then they brought in Jeff and is like, Wendy absolutely said that Charlie said that, whatever. So when they bring them in by Wendy Adelson against Charlie Adelson, they are statements of a party opponent. So they're bringing in Charlie's statements to Wendy and using them against Charlie. It becomes different when you are saying Charlie said this and then using them against Donna, but Donna's a co-conspirator, but we have a Sixth Amendment issue, but they are co-conspirator statements, and that might be the exception to ask Wendy about them. And then if Wendy lies about saying that, then yeah, you can bring Jeff in to impeach Wendy, but then the statements are not offered for the truth. They're offered for impeachment. Oh, Your Honor may remember that in Charlie's trial, the court granted the first part of this motion. However, the state was allowed to question Wendy Adelson about these topics, and the state was then able to impeach Wendy Adelson by asking the same questions to Jeff. That should not be allowed in Donna's case because unlike with Charlie Adelson, in the first instance, these matters have nothing to do with Donna Adelson and do not survive a 403 inquiry. So they're saying, again, these statements don't come in because they're not being offered against a party opponent. They're being offered against Donna. But again, there's a conspiracy. Statements of co-conspirators can come in even if they are hearsay in some circumstances. So we'll see. Testimony from Wendy Adelson. See, the defense knows these attorneys were on Charlie's team. The defense is as well familiar with this case as the prosecution is. They've all done this case a million times before. So now they're like, okay, just like roll it back and go again. One more time. One more time. One more time. During Charlie Adelson's trial, the state questioned Wendy Adelson about one, the characters and storyline of a fictional book that Wendy authored about human trafficking. There's a book? What? 2, name changes of her children. 3, Wendy's willingness to allow Professor Markel's parents to visit with her son since 2014. And relatedly, 4, the Markel's successful efforts since 2014 to lobby for the amendment of Florida's grandparental visitation rights laws. So those are all topics that Wendy was questioned about in Charlie's trial. I don't know what the book has to do with anything. The substance of Wendy's fictional book written years before the professor's death, I mean, just a fictional book about human trafficking. But Wendy was also a law professor, so cautionary tales don't seem like out of left field to me. And it doesn't seem specifically related for this. Rebecca's in the chat said, Emily will need a shelf for books written about cases. Yes, I do. I need a shelf in here somewhere. I mean, we're not moving the caterpillar. I need a shelf in here somewhere of like the bad idea book, the bad idea bookshelf. And we're just putting up the bad idea books, the bad idea bookshelf. But I don't know how this book becomes an issue. So I don't know. I haven't read the book. I don't know how it's related. And again, she was a law professor, so I don't know if the book is more of a cautionary tale because, it's like one of the central things you do when you work in academia, isn't it? Like writing books is a huge part of your job or advancement. I don't know. A lot of my law professors had book, but I definitely need a bad idea bookshelf. Tracy Summers in the chat said, publish or perish, people. Publish or perish. That's exactly what it is when it comes to academia, not when it comes to Corey Richins, Courthouse Becky, Keefe D, though I found his book fascinating, Bad Idea Bookshelf, which means I have to buy like trophy books because I listen to everything on Audible. Audible's not our sponsor today, Foreo is, but I listen to everything on Audible, so then I need like trophy books. So Virginia said it's fiction though, not academic. Fair. Let's see. The book was a thinly veiled autobiography preview of Wendy hating Tallahassee and moving to Miami. Interesting. Emily, it was a fictional book about being in a bad marriage. So you're telling me the book actually isn't about human trafficking? Interesting. All right. Maybe we do need to take a look at the bad idea book. Let's see. The substance of Wendy fictional book. Well, these lawyers aren't writing a book. Wendy's fictional book, written years before Professor Markel's death, name changes for the children. I can understand name changes for the children coming up. I think it still will. Visitation decisions she may have made in the wake of Professor Markel's death and legislation enacted in response to the death have no probative value. And the only question this jury will be asked to decide is Donna Adelson's guilt or innocence to the crimes charged. The name change and the visitation, though, kind of go into motive in what was going on with the family here. So I understand why the state wants to bring it in. I would need to know more about the book. Footnote 6, we've conferred with the state on this motion. The state opposes it. Jailhouse recordings. This is what we wanted to get to. This is the part. Hold on. Jailhouse recordings. Wait, where are my claps? Damn it. No, that's not that one. This is what we wanted to talk about. We wanted to talk about the jailhouse recordings. Your calls are being recorded. At trial, the state will likely seek to introduce recorded telephone conversations between Donna and Charlie. They fucking will. They absolutely will. They're gonna want to play it in their opening. I don't want to play it in my opening. Click. Ooh, look. Prosecutors are going to use the shit you say against you. It's why many lawyers follow the shut the fuck up thread of advice, because what you say will be used against you, right? Prosecutors will take your words. If your words are recorded, push play. The prosecutors were listening to those jail calls going, no, she didn't. No, she didn't. No, she didn't. No, the fuck she didn't. Yes, she did. There she goes. And then speculation went to their coworkers and are like, you're never going to believe what happened on this jail call. And then not only was there a jail call, the jail call was left open. Like the line was left open. And so it records not just the jail call, but it records the conversation of individuals in a room together talking about this flight because they leave the line open. The recorded line stays open forever. It's the ultimate self-snitch. All right, jailhouse recordings. At trial, the state will likely, you've read that situation correctly, seek to introduce recorded telephone conversations between Donna and Charlie while the latter was held at the Leon County Detention Center following his conviction last fall. While Miss Adelson's statements may be admissible under Florida law, Charlie Adelson's statements are hearsay for which there is no exception under Florida law. They're going to be arguing co-conspirator, and they're going to be arguing that this is in furtherance of the conspiracy because cover-up can be part of a conspiracy. So I think they're going to argue that this is part of an ongoing conspiracy to cover it up. So Charlie Adelson's statements are hearsay for which there's no exception. Moreover, certain of Donna's statements are highly inflammatory, posing a significant danger of unfair prejudice for Miss Adelson. Your Honor, she said shit that the jury's not going to like at all. Posing significant danger of unfair prejudice and therefore must be excluded. They didn't put much more into that. We have conferred with the state on this motion. The state opposes. Yeah, they do. So I'm not surprised that the paragraph is this big because they're like, please exclude them. That's not going to happen. Autopsy photos. During the trial of Charlie, the state was permitted to introduce 10 separate exhibits, 2 x-ray images, and 8 photographs from Professor Markel's autopsy, along with 3 photos of Professor Markel after the shooting, but before his passing at the Tallahassee Memorial Hospital. The Florida Supreme Court has held that autopsy photos are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of the deceased victim must be probative to an issue that is in dispute. Here, Ms. Adelson does not dispute the fact, means, or manner of Professor Markel's death. Accordingly, any probative value of the autopsy photographs is substantially outweighed by their prejudicial effect, and we ask that they be precluded. Footnote 8. We have conferred with the state on this motion. The state opposes it. The state has to prove that Dan Markel was murdered for there to be a conspiracy to commit murder. They're allowed to prove that up. That element has not been stipulated to. I don't think the state would stipulate to it, so that's not going to go very far. You see, they put the ones at the end that the court's going to deny. The court can limit the amount of cumulative photos and horribly graphic photos. It doesn't sound like that's what was done here. It sounds like there were a limited amount of photos and x-ray images. So those last two are probably going to be denied. The first one's probably going to be granted. We're going to see Wendy testify when this goes to trial. So we will see how that goes. The next hearing on this is going to be September 12th. There's another date for other things to be filed, but September 12th is the final pretrial hearing where we will hear a lot of this. So we've gone through the motions in limine. We've gone through the motion to dismiss. We've gone through the motion to exclude travel. We're going to take a look at why Donna wants a smaller courtroom. And then we are going to go through the potential or the proposed jury questionnaire and see what these jurors will be asked. The court was saying that they think it might take almost a week for the jury to be selected. So we'll take a look at that questionnaire and see what they're asking and see, if they're asking about newspapers or if they're actually asking about YouTube. One never knows with these motions what they're asking about. So we'll see. It's always funny to me how sometimes outdated the references to media are in those jury questionnaires. Defendant Donna Adelson's motion to hold trial in courtroom 3B. Ms. Adelson's upcoming trial is scheduled to proceed not in this court's regularly assigned courtroom, but in courtroom 3G, which, as the larger of the two, can accommodate more members of the public in the gallery. It is a public trial. So, the decision to use courtroom 3G was, we imagine, in response to the public's demonstrated interest in this case and in keeping with Florida's Supreme Court's position that the public should generally have unrestricted access to all judicial proceedings. As the Supreme Court made clear, however, the public's right to access is not absolute, but it must yield in order to protect the defendant in a criminal prosecution from inherently prejudicial influences which threaten the fairness of his trial and the abrogation of his constitutional rights. Where a defendant's right to fair trial conflicts with the public's right of access, it is the right of access which must yield. Unfortunately, as we learned during Charlie Adelson's trial, in a highly publicized case like this one, the more observers there are in the gallery on any given day, the greater the risk to the defendant's constitutional rights. I'm interested to hear what they say happened in Charlie's trial. In Charlie's case, for example, someone in the gallery took a photograph of a note passed between Mr. Adelson and his counsel. Don't do that. See, this is why we can't have nice things, because people go into court and then they don't follow court rules. If people go into court and fuck around, then yeah, you're going to have the court say, all right, well, then you're out. It's going to be streamed and you can watch it from streaming. I think there is value to people having the right to be in the courtroom. But if people do shit like this, I can see why they're like, the less people, the easier it is to enforce the rules. If people do this, if this was done, and I imagine that this is the same judge, so this judge knows if this is true. I can't imagine the defense would make this up or exaggerate this. In Mr. Adelson's case, for example, someone in the gallery took a photograph of a note passed. This is why they take phones away. And I might do that in this case too, and take the phones away from anyone in the gallery. So, I mean, that's one way to handle it. You don't need a smaller courtroom. You just put the phones in Faraday bags like they do in federal court. Let's see. Mr. Adelson and his counsel on the second day of jury selection and proceeded to post the note on social media. While the substance of the note was unrelated to Adelson's case, the reporting in the media speculated about the note and its importance. Moreover, the fact that it was photographed and released for public consumption forced defense counsel to modify how and when they communicated with Mr. Adelson for the duration of trial. Well, Yeah, people shouldn't be photographing what's on counsel table, shouldn't be talking about what's on counsel table. And sometimes that's really, really hard to do. It's why counsel should always have those, like, on the laptop screens, those reflectors, so that the people behind you can't see what's on your screen. It says, even more significantly, later on in the proceedings, during the cross-examination of an important government witness, one of the jurors stood up in the middle of the examination and signaled to the court to stop the proceedings. That must have been wild. After the court spoke with the juror, we came to learn individuals in the gallery were making facial and hand gestures towards the jury in an effort to convey opinions on the testimony. What? What? You what? You can't do that. You can't do that. You can't do that. There are rules of decorum in court, and more strictly enforced rules could solve this problem. You have a bailiff that has to sit there and watch the audience so they're not making facial expressions and gestures, and they're not just sitting there going, like, members of the audience can't try to influence the jury through, like, mad dogging them or just being like, So the judge can just yeet people out of the courtroom if they're making facial expressions, though. After the court spoke with the juror, we came to learn the individuals in the gallery were making facial and hand gestures towards the jury in an effort to convey opinions of the testimony, which were distracting to at least one juror who complained of the incident. Good for the juror. Absolutely good for the juror. So let's see, which were distracting to at least one juror who complained. Good. Actions like this may clearly affect the juror's ability to independently assess the testimony. There are court rules to do that, but they're not asking that the courtroom be sealed. They're just asking that there be less members of the gallery, which might make it easier to enforce the rules. And at several points, the proceeding was interrupted when members of the public, contrary to the court's clear admonition, attempted surreptitiously to record the proceedings and failed to silence their cell phones. Take the cell phones. Take the cell phones. Take the cell phones. Look, I've been to multiple comedy shows where they take your cell phones and your, like, Apple Watch and whatever. We have the technology to make this work. Take the cell phones. Just take them. That's not hard. In a case with tremendous attention and strong opinions that is covered virtually every single day in all sorts of social media and other outlets, there is a risk of a large live audience creating a sort of mob mentality in regard to reactions to testimony. By limiting the size of the audience, this court limits the probability of emotional outbursts and reactions in the gallery. Simply put, the larger gallery audience elicits larger responses to the testimony and thereby a larger chance to influence the jury. I think there's other ways to do this other than the smaller courtroom, and I think the court can do that. So, and maybe the court should just take the phones, and then if people are making facial expressions, which they're admonished of, they just get removed from the courtroom and excluded permanently. Let's see. All of these types of incidents described above, should they occur during Adelson's trial, will threaten her ability to secure a fair trial and risk a mistrial, which no one wants. While Your Honor certainly does his best, Your Honor, we're not blaming you. The easiest way to mitigate these risks is to reduce the number of in-person observers to reduce the number of in-person courtroom observers, which this court can readily achieve by ordering that the trial be held in the smaller courtroom 3B. To be clear, oh my God. Just be clear. If you have to say to be clear, you're not being clear. Just be clear. We are not asking this court to prohibit the public's access to the trial or to not respect and adhere to the public's right to have access to judicial proceeding. Indeed, members of the public will still be able to attend trial just as they would be in courtroom 3G. The courtroom will still have a live feed camera, so for anyone unable to attend in person, if past is prologue, Miss Adelson's trial will be televised live on a national network. Yes, the national network of YouTube. And as you are aware, many of your trials are routinely held in courtroom 3B. Your Honor, can we just go to where you normally go? And none of these cases violate the Sunshine Law's rights of public access. That's a weird sentence, but they're saying the public can still attend. We're just limiting the number of public. Can we go back to the normal courtroom? On a separate note, courtroom 3G as is currently configured, also creates logistical issues for the defense counsel that did not exist in courtroom 3B. They should have led with this. If they learned anything from the Karen Reed case, lead with the logistical issues, not we don't want the audience. Just lead with that. Among other things, it is virtually impossible for the defendant or her counsel to see all of the jurors while seated at counsel table. Lead with that. Lead with that. Your Honor, in courtroom 3G, we can't see all of the jurors. We need to be able to see all the jurors throughout the testimony. It's part of the legal strategy. It's part of a vigorous defense. Lead with that. Why are you bearing this as your second argument? This is a good argument. We can't see all the jurors. That's a good argument for moving it. Further, the lectern's placement immediately to the right of the state makes it difficult for defense counsel to use the Elmo or other electronic devices during examinations and makes it difficult for counsel to see all jurors while the examination is occurring. Then that. Moreover, the gallery is in direct view of the jurors while examinations are occurring, which can cause attempted influences from the public. I mean, the gallery is always in direct view of the jurors. All of those concerns are not prevalent in courtroom 3B. We know Your Honor has and will do his best to ensure decorum in your courtroom, but there's only so much you can do, especially in a case with as much coverage and public interest and emotion as this one. We'll see what the court decides to do. I think the stronger arguments should go at the beginning. Your Honor, we can't see all the jurors. Good argument. Good argument. We can't see all the jurors, and that's part of a vigorous defense. We can't defend our client. Instead, they spent a whole lot of time talking about the public, which seems like they are trying to limit the public's access in the courtroom. And they're like, no, we just don't want as much of the public. Like, we want a few of the public because we're not saying the public can't come in, but we don't want a lot of the public. No, they should have led with, we can't see the jurors and we can't do our job, and we can't do our jobs effectively. That's a stronger argument. We'll see what the court decides to do. Am I as fussed about that? No, these things, people's behavior in court is going to continue to come up. People's behavior in high profile cases is going to continue to come up. If people go into court and are in the courtroom, they have to adhere to the decorum orders. And I think we're going to see more and more courts just getting Faraday bags and locking up phones and being like, whatever, you can come in, your phones are locked, you get them back at the end of the day. And that's it, which makes the feed so helpful and allows the public to have access to courts while the courtroom logistics don't get disrupted. I think there's a balance there. So we'll see what happens with that motion. And then we need to look at the proposed juror questionnaire. So let's do that next. We've got quite a lot of motions today. I told you that we would. Let's see. I did not do this right. Hold on. Give me my link. Give me link or give me, well, nothing else to stream about and going directly to questions. No. Let's see what the proposed juror questionnaire is. They are suspecting it might take 5 days to pick a jury. Let's see what the jurors are could be asked. This is a proposed jury questionnaire, so this has not been approved by the court. It's not been approved by the prosecution, but the defense wants to use a questionnaire. It's not a bad idea in a high-profile case. So let's see what they are proposing. This questionnaire has been prepared to assist the court and the parties selecting the jury in the case. Please answer each question completely and accurately. Your complete written answers will save a great deal of time for the judge, the lawyers, and you. Your answers will have the effect of a statement given under oath. Fill it out completely. Your very best honest effort to answer the questions is needed. It's an odd sentence. There are no right or wrong answers to any of the questions. Please answer thoughtfully, thoroughly, and candidly. Full name and juror number. You're being considered as a potential juror in the case of State of Florida versus Donna Adelson. This case involves the murder of Dan Markell in July 2014, who was shot in his car at his home in Tallahassee. Mr. Markell was a professor at Florida State University College of Law, and he was the former son-in-law of Donna Adelson. 4 people have either pled guilty or been convicted of that's a lot of information, or been convicted of the murder of Professor Markell, including Charles Adelson, Donna Adelson's son. Donna Adelson has been charged with murder in the first degree, conspiracy to commit murder, and solicitation to commit murder. She has pled not guilty to these charges. That is a very thorough statement of the case. There has been media attention to the events surrounding this case. There is nothing wrong with having seen, read, heard about, talked about, or having formed opinions in this case. We simply need to know what your knowledge and opinions are. That's not neutral language. Please answer the following questions thoughtfully, completely, and candidly. That's that's a lot. That's a lot. How would you describe the amount of media coverage you have seen about this case or the defendant, Donna Adelson? A great deal. Follow it very closely. Quite a bit. Read many articles and watched television accounts. What are television accounts? They mean accounts on TV, but whatever. Moderate amount. Just basic coverage in the news. Little, basically. Just heard about it. None. Have not heard of this case before today. Has your information about this case or the defendant come from, check all that apply, newspaper, including newspaper websites, print periodicals or magazines, television or radio, podcast, social media, including Facebook and Twitter, websites other than online newspapers or magazines, which, hearing people talk about it, personal knowledge, other. Notice that they always leave out where people are actually getting information on social media. Trials are talked about on TikTok and YouTube. Yes, they are talked about on Twitter. Yes, they are talked about on Facebook. But it's just hilarious to me that they always leave out YouTube and TikTok because that's where a lot of people consume information. So if you checked personal knowledge or other, please explain. I think that's a confusing question. But okay. I guess maybe not. What have you seen, heard, or read about this case and Donna Adelson? I think it should say and or. What are your thoughts? I'm not editing this. Emily, stop giving feedback. You're not editing it. What are your thoughts and opinions about this case and or Donna Adelson? Have you had conversations with others about this case? If yes, what have others said in conversations about Donna Adelson? What have you said in conversations about Donna Adelson? Have you done any online research on this case since you received your jury summons? That's interesting. Oh, there it is. If yes, please describe. Do you listen to any true crime YouTube podcast channels or programs? If so, which ones? Name them. There it is. If you're going to bring up YouTube in question 7, I mean, maybe just put YouTube up in here where it says social media. Oh, Miguelina, this is a Firefox specific issue that my cursor doesn't point where it's supposed to point like it does when we use Chrome. We should make a note of that. Thank you. What have you said? What have they said? Do you listen to any YouTube podcasts? YouTube podcasts. What did you think or feel when you received your jury summons for this case? The judge is not going to allow them to ask that. To the best of your recollection, what kinds of things did you say to others or did others say to you regarding your possible jury service in this case? That's probably going to get reworded. As a result of what you have seen or read in the news media or what you have learned or already know about the objection compound as fuck. As a result of what you have seen or read in the news media or what you have learned or already know about the case from any source, have you formed an opinion that Donna Adelson is guilty? Yes, no, unsure. That Donna Adelson is not guilty? Yes, no, unsure. Notice that they didn't, the defense writes this when there's no box for I've not formed an opinion. Oh, this isn't neutral at all. This is going to get reworked. I imagine the prosecution is going to be like, no. If you have commented on this or any related case in any form of media in an online comment or post, or if you have shared a post, please describe. No. Please tell me everything you've shared, retweeted, commented. Have you ever commented on a live stream? Tell me what you commented. Oh boy. Oh boy. That's gonna get reworked. The prosecution is going to be like, what we're not going to do. But this statement of the case is so far from neutral. People are going to get through this statement of the case and be like, I didn't have an opinion until I read this. And now I do. The juror questionnaire is what formed my opinion of the case. That's what's going to happen. So this the proposed juror questionnaire is not going to go very far in this. So that's interesting. But the defense wants to use a jury questionnaire. I think a jury questionnaire is a good idea. I don't think that one is what's going to fly, but the jury questionnaire is a good idea. The Cozy Treehouse quote. So yeah, I called someone Crash Daddy once. It's like, what would you respond to your comments on the case? Talk dirty to me, Law Daddy. I made a joke about Wood Daddy Stacks in a live chat once. It's not really related to this case, but who can remember what case it came up to? Sarah in the chat said, what does YouTube podcast question make me think of? How do you do, fellow kids? It really does. It really does. It really does. And it makes me just, it's like, oh, okay. Oh, okay. It's just, Alexandria in the chat said, well, it should be recommended for jury duty that someone watches and engages in Emily's YouTube podcasts in the chat. Sometimes they're podcasts, sometimes they're not. I love that all of you are like, I remember that. I remember that. It was absolutely, I remember it too, Stacy. Stacy's like, I remember what that was about. Yeah, it was about Real Housewives. That actually might be relevant to the Girardi case. Sarah said, get in the car, Elizabeth. Things we've said on the tubes. We've said lots of things. We have lots of jokes here. Not many of the jokes surrounding this case, but we have lots of jokes. But we'll see what happens. Lyndon said, I've heard Dick Harpootlian complaining about podcasters. Exactly. Oh, that was so many motions today. Let's summarize those. Let's go to Q&A, and then I'm going to have to take a nap. That's Emily. How are we doing in the day? Good, until I hit a wall, and then my brain stops and I need to nap. But next week, we're just going to be in court. So it's going to be fine. We have plenty of time to recover. We're just going to watch what's going on with Corey Richins next week. I can't believe it's going to be a 3-day preliminary hearing. I mean, I'm here for it. I want to know everything. But it just seems like the preliminary hearing could be done in like 3 hours, not 3 days. It's a really high level finding a fact, because the standard you have to meet, like the more likely than not, like she probably is the right person to go to trial on this. That standard's not very high. And a lot of that can be done by 115, which is law enforcement introducing evidence. Like it's interesting to me that it's going to take 3 days. I'm curious as to why they're choosing for it to take 3 days, but I'm here. I want to know what's happening. I want to know what's happening. And I imagine they're just going to bring in all the live witnesses that we're going to see in trial. So it's really going to be like a mini trial preview without a jury and with more loose rules of evidence, especially when it comes to hearsay. So we're going to see quite a lot. Sweet and Salty asked if I'm going to cover Donna's trial live. That is the goal. There may be a few weird days in there based on some travel I have at the end of September. But yes, my goal is to cover Donna's trial gavel to gavel. I'm really interested to see how they're tying her as like the center spoke in the wheel of this conspiracy. Conspiracy cases are really interesting to see how different prosecutors build them. I mean, or don't, if you're keeping up with everything that's going on in the YSL case, where the judge is sitting there going, excuse me, do you have evidence? Do we know what we're doing? What are you introducing? What are you not introducing? What is happening? So yes, I'm going to be covering the Donna Adelson trial. I will keep you posted as to how we're going to be doing that. Oh boy. All right. So let us get to a quick summary of that and then some questions. Today, we went over a whole bunch of motions in the prosecution of Donna Adelson. Donna Adelson is being kind of charged as the center spoke in the conspiracy to murder her son-in-law, Dan Markel, who was her daughter's husband, the father of her grandchildren, after an acrimonious divorce from Donna Adelson's daughter, Wendy. Her son, Charlie, has already been convicted. The middleman and the shooters have already pled or been convicted. So Donna seems to be one of the last prosecutions. Her husband and her daughter have not been charged in this case, and many are still wondering, why not? So we are looking at this case going to trial towards the end of September. And because of that, we got all of the motions in limine and the motions to exclude evidence. Donna Adelson would like this to be in a smaller courtroom, alleging that during the trial of her son, Charlie Adelson, members of the gallery were taking pictures of a note passed between Charlie Adelson and his attorney, and that they were signaling to jurors what they thought of the testimony, to the point where a juror actually stood up during testimony of a witness and interrupted and told the court that members of the gallery were signaling. And then they also argued at the end of that motion that no, the courtroom really is too big, and we can't see all of the jurors the way this courtroom is set up. So we need to be in the other courtroom. It has a smaller gallery, but also the defense attorneys can see the jury better, which, if that's true, might be the argument that carries the day on moving courtrooms, because if they truly can't see the jury well, then that can be an issue for any of the attorneys in the case. And that might be the thing that gets the courtroom moved. But again, the trial will be streaming, and they said, look, the public will have access to it one way or the other. I think all courts are going to start taking phones when people enter the courthouse and putting them in locked bags like you do if you go to a comedy show or some concerts or federal courthouses, because of issues like this. We also went over the motion to dismiss the case or exclude evidence due to delay. Donna Adelson, through her attorneys, are arguing that, hey, this murder happened in 2014, and in that time, the state didn't preserve evidence of all of Donna Adelson's cell phone records. And by the time they finally charged her, those records are gone and no longer held by the cell phone carrier. And the same with her son pass for the Florida Turnpike. We want to get those records to show that she wasn't at her son's house the night that you say that she was dropping off money as a part of this conspiracy to commit murder. But we don't have those records because the state didn't preserve them closer in time to when the murder happened and delayed in charging her, even though they knew within hours of this murder that she might be a potential suspect, and in the weeks following and years following did become a suspect. But now they're bringing her to trial, and it's just too late because all those records are gone and they could be exculpatory. So the court should either dismiss the case or limit that evidence coming in because the state waited so long to charge her. It's not as if there's new evidence. And they argued quite a lot in that motion that the state is relying on evidence gathered back in 2014, 15, and 16, not evidence that came to light of the state in 2022, 2023. They also argued that her travel to Indonesia was not her fleeing the country after her son was convicted. It was just regular international travel. And so that can't be used by the state as a consciousness of guilt. They can't say, look, she knew that the walls were closing in, so she was fleeing, because there's other excuses or other explanations. Emily, how do you feel about this motion, really? Well, I said excuses instead of explanations, so I guess we know how Emily feels. There are other explanations for that travel, and she knew she was a target of investigations for almost a decade, and she knew that there were future prosecutions, and she didn't flee when her son got arrested. So she's not fleeing now. She was just traveling. And so we can't allow the state to argue that that was flight, evidence of consciousness of guilt, and the jury can't be allowed to hear that her bouncing out of the US was in fact her fleeing. And because she talked so much about that plan to leave the country and why that was their plan B in her jail calls, they also made a motion to exclude a lot of those jail calls, or at least exclude the statements of Charlie Adelson, saying that those are hearsay, that because Charlie's unavailable to testify, because even though he's been convicted, he still has an appellate right, so he can still plead the fifth. He can't be compelled to testify in this case, that he can't be confronted. So there is a Sixth Amendment issue there if the state tries to use Charlie's statements on the jail calls against Donna. So there are some really interesting motions here. I think some testimony that the defense asked to be limited will be limited, but they also said the court limited that in the trial of Charlie Adelson. Same judge on this case and this prosecution, some of the same defense attorneys on this case, and the same prosecutors. So everyone's done that once before and together. So it's really one more time for everyone involved. So the defense attorneys really have a good perspective of how the state's going to present their case, because the state has done 4 other prosecutions with regard to this murder, and this, what they're alleging, is a conspiracy to commit murder that others have been convicted of. So yes, the arguments about the co-conspirator statements will come up. The jury selection for Donna Adelson starts September 17th. After jury selection, I will be covering this case on the channel. So if you have the Law Nerd app, stay in the loop of what I'm covering that. There will be one more pretrial hearing in early September that I hope to cover as well. So hopefully that'll be streamed, and we will be covering that here. So Law Nerd app is where you need to be. Let's answer some questions. Are we ready? Let's go. So we're going to go to our questions real quick. Thank you, everyone, for the well wishes. It's good to see you. We are hanging in there. Kelsey and others, I saw lots of you say that there were birthdays today in the chat. Happy birthdays. Nana Banana 9 said, I can't believe it's been 2+ years. I love this community. I love this community too. Christy, the travel queen said, drinking Cinderella cold brew. I don't know. What is a Cinderella cold brew? And watching EDB makes a happy day. Grande pumpkin cold brew and 2 pumpkins white chocolate, adjust for size. So that is I'd never heard of the Cinderella cold brew, but there we go. Thank you for describing it, because you knew I would ask what it was. Evelyn Roberts, thank you for the super chat, which said off topic. Sorry. Reminder for all AFAB people to do their scheduled mammograms. Breast cancer is the most common cancer in AFAB people. My mom was just diagnosed with breast cancer. I'm sorry to hear that, but the prognosis is good so far because it was caught early, which is why mammograms are so important. So there's all kinds of preventative healthcare that is not fun, but important when adulting. And listen to your doctor's recommendation on when those tests are appropriate. Sometimes they are earlier depending on family history. So absolutely, absolutely make sure to do that. It's a good reminder. And I hope that everything goes well with your mom. It is a journey, but lots and lots fight that battle and win. So good luck and well wishes to your mom. It's not an easy journey, but it is absolutely a journey. Hannah said, just had to let you know that while you've been live, I've completed multiple loads of laundry, dishes, and decluttered my kitchen. Thank you for body doubling today. I needed it. I was looking for my applause immediately, because all of the applause. So, all of you that are in the chat, if you have been body doubling with me today, please feel free to share what you have accomplished today so we can cheer you on. Sometimes it's as simple as, I got up and showered today. Congratulations. Sometimes you got all the things done. So whatever you've done today, congratulations. You've got this, and I applaud you. Malleus Maximus, good to see you, said, Emily, I'm about an hour behind in stream, but just got to Donna's flight. I'm a resident here for 20 years. It's prohibited to not have a return flight as a tourist, so she definitely had something going on. I didn't know that in Vietnam, it was prohibited not to have a return flight. Very, very interesting. Ice Ice Baby said, excuse me, can you please explain why you're discussing Linda's clam and what that pertains to? Can you imagine a jury questionnaire being like, well, I've commented a lot of things. Just a lot of things. Music to My Soul said, Emily, motion to start a Bad Idea book club. Here's the reason why I wouldn't. Music to My Soul, I think it is a cheeky idea, but I don't want to bring infamy, and I don't want to put more cash in like Courthouse Becky's pockets by doing it as a book club. But will I discuss the books with you? Yes. Do I want to encourage people to buy them? Not necessarily. Because I think sometimes the infamy is not great. Dolly said, I processed 376 orders for shipping and got returns done. That's amazing. That's amazing. Working on a mock-up for a possible color guard show top, Amy. That's amazing too. We love working on a mock-up for a show. Kara said, vacuum mopped and dusted all of the downstairs, cleaned my bathroom, showered, and cut my hair all while the baby napped. Kara, that's amazing. Jules said, I'm getting caught up on work. My boss gave me a special project. Thanks for helping me through. Best Pouble said, I got approved for an apartment today. Congratulations. You guys have done all kinds of cool shit. Look at this. Mars said, I finished cross-stitching the last Christmas stocking for my extended family. Excited to see it together next. Amazing. Aloe Vera said, body doubling at work and also studying Italian. I love it. You're like, we're doing everything. The Double Helix said, I'm unpacking from a big cross-country international move. It never ends. Unpacking never ends. I'm still not unpacked from going to Boston. There are times I'm not unpacked until I have to pack again. And then I'm like, oh, that's why I thought those pants were missing. Goldalicious said, I got all my steps in. I walked on my walking pad for a half an hour. Awesome. I need to get one for my office. I keep meaning to do that. Getting my program plans done for work before they're due. Look at that. Lisa managed to mend her husband's shirt. And Prey said, I completed lots of mandatory education for work. Perfect. RK said, making beef stock soup for sick kiddo. We have sick kiddo at this house too, and me. And I can get Demoses in Murfreesboro. So I have not been making soup. I have been having Dr. B pick up Demoses. That's what we've been doing. Janet made peach preserves. Amazing. Amazing. Rachel said, rewatch the Amber Depp trial with your commentary and clean the bathroom, sitting room, kitchen, bedrooms, and 5 loads of laundry. Thank you. Look, I'm here to body double with you guys all the time. I'm here to body double with you all the time. It's what we do. Look, it's part of the law nerding. People are like, Emily, your community watches like a lot of long live streams. I'm like, yeah, because they're doing other stuff. There's this whole side of YouTube that's like, you've got to do like a cut every 3 seconds to keep people's attention. I'm like, yeah, no, I don't do that. I don't do that at all. People will pay attention, or they will do the other things they need to do, and they will learn in the background while I'm still chatting with them, like we're just sitting having a conversation, and they body double do work. I'm not going to put in loud noise effects on purpose, and I'm not going to change, the pitch and sound of things and put in that annoying freaking dolphin noise or whatever to bring people's attention back. Trust, when we need to bring people's attention back, we just do that gently. Y'all come back. There's important shit happening. That's all. We don't need cuts every 3 seconds. We just do it differently. We just do our own things. Look, and everybody's got split attention, which is perfect. For us, it works well for us. Nobody needs to understand what we do. It's like, we do our own thing. Anita, thank you for what you do. Anita says, I take care of children with brain tumors and spent the last hour listening to EDB with one of the moms and making her laugh. Thank you, Law Nerds. Anita, thank you for the work that you do. And I am sure the emotional load is quite heavy. So thank you very much for the work you do. And look, we're here to help bring a laugh, because life, unfortunately, the older we get, which we know, because this is a wise audience. We've seen some shit. We've lived through some shit. We know that life can be hard. But this audience is there for a moment, right? Lindsay, thank you for the 5 gifted memberships. Appreciate it. Music to My Soul said, Emily, thank you for streaming today, even though you're sick. My sister's 21-year-old cat passed today, so it is a welcome distraction. Look, the loss of a pet is uniquely gutting. It is so hard. And my beloved... checks for Fred and George. My beloved Albus was 17 when she passed. And it is, look, the orange boys are not the same as my soul animal. These are teenagers. The teenage orange boy cats are the teenagers that match my teenager. They are all teenagers. I have a house of teenage boys, including those cats. But Albus was 17 when she passed, and it is uniquely painful. So I am sorry. It is a hard loss. It is a wonderfully lived life, though, to have a 21-year-old cat. That is absolutely incredible. So it's one of those things. It's like, it's a beautiful long life for a pet, and then it's gutting when you lose them, but a beautiful long life for a pet. Nutmeg said, I am in bed with COVID number 4. Nutmeg, I get it. I'm one of those folks with you that every fall, it's just like, here is my annual, my annual getting sick. This one for me hasn't been as bad. Some people have been worse this year than in past years. Some people have never gotten it. Some people get it all. I don't know. It's just, it's fall. And for those of you that are like, EDB, it's August, it's not fall. Yeah, I know, but school's back and football's back and pumpkin spice is back. So it's fall in my brain. It's like fake fall number 2. Today it wasn't 80 degrees when I woke up. It felt like fake fall number 2. But for those of you that are in like Texas, it feels like this third summer number 7th layer of hell. So I get it. Kirby said grandkid forgot color guard flags. We all took a ride. She loves you and wants to be a lawyer. Lawyering is an adventure. And sometimes we forget things at our house too. I totally get it. Cheryl Ray said adulting in all forms is hard. It really is. All of it. Fezziwig said while recovering from knee surgery. Look, I love having something to pop on and listen to while I'm recovering. It's normally audiobooks and then other streamers, but not the screamy ones that play video games. I can't. I need people to chat with me, not scream at me. Avarice said my cat was 20 when she passed, and I was absolutely gutted. And then I got a dog to soothe the soul since I couldn't bear to get another cat until my baby boy Django. I get that too. It's hard. But for all of you that are recovering, from all of you that are celebrating birthdays, from all of you that are going through it, I'm here. The community is here. I'm glad to see you here. We have lots of court next week. Quick Bits is up on the Quick Bits channel for those of you that need to catch up in between things. It's why we started the Quick Bits channel, because I know that there are some days when you can't keep up on a case, or it's not your favorite case and you're like, I just need the summary so that I can hop on the next live. That's what Quick Bits is for. If you have the Law Nerd app, then it will remind you when there are new Quick Bits. So those are our breakdowns. And then on Monday is a summary. Sometimes it's cases I've covered here also. Sometimes it's new information that came up after I streamed. So Quick Bits is where it's at. Don't miss Quick Bits. It's also in your audio feed. I will be back in court with you next week. We will see how streaming goes for Corey Richins. The court had allowed streaming of the bail hearing, but didn't allow streaming of the last hearing. But then there was some. We don't know what the court's going to do, but I will keep you posted in the Law Nerd app. It is my intention and goal to be streaming with you from Utah on Monday. So I am getting ready. To take a flight with you to Utah for 3 days and then to Idaho for the 4th day. So we'll be back in court a lot next week. I'm going to be resting this weekend. Hopefully you guys get done what you need to get done and are ready for court next week. You guys have a heads up. Members, we will be together Wednesday evening if all goes well. So chat. We will see you soon. I appreciate you. Thank you for being here. Thank you for being a Law Nerd. I'm happy to see your productivity. I'm going to go productively nap. That's what we're doing next. And I will see you soon. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with Quick Bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the Quick Bits. Thanks for being a Law Nerd.